I'll call to order this February 24, 2020 continuance of the Seattle Waterfront LID assessment hearing. Today, objections will be heard from hearing examiner case numbers 336, 337, 339, 340, and 342. Those may be continued through Wednesday. We'll take a break at approximately 10 a.m. Lunch will be approximately noon, and then a final break at about 3 o'clock. Who do I have with me today?
Darby Ducombe, Your Honor, on behalf of the property owners.
Okay,
Molly Terwilliger on behalf of the property owners.
thank you.
Gabrielle Thompson on behalf of the city.
Christina Kalegi for the city.
Thank you. We'll proceed with.
Thank you, Honor. I just had a couple little preliminary matters. One, I had a question about whether the notices of the assessment were already a portion of your file, or whether we should bring those in as exhibits.
I don't believe anybody's introduced that as an exhibit yet.
Okay.
Yeah.
Like in general or for this matter, or?
In the hearing at all. Right now, some parties may choose to adopt by reference other parties' records or such. So right now it's a consolidated hearing.
Okay.
I'm really hearing each case based on what they present unless they incorporate others.
Okay.
You could do that, but just to let you know where we've been, essentially mostly we've had individual or pro se litigants, and so there hasn't been an established record of. We don't even have an exhibit number yet for the various assessment documents.
Okay.
So
Okay.
there's really no established record that you can refer to for
Okay.
the most part, unless you've gone back to an objector's file and say we want to refer to that, or you're just generally referring to everything.
All right, we'll make sure we get copies of those into the exhibits then. And then it does sound like we'll be able to keep the record open, and there'll be some procedure to examine the city's witnesses, adopt other witnesses that the other property owners are still working on. I know for ourselves, there's still a lot of work to be done with cost estimators, architects, engineers, planners, and other folks to potentially complete the record for ourselves for our appeal. And we're coordinating to keep that as efficient as possible with the other owners. But just wanted to make sure, just as a preliminary matter, that we'll be able to keep the record open at the end of today or Wednesday, whenever we conclude today, as the rest of the proceedings unfold.
And the way I'm approaching that is that parties have been dedicated. I really have to approach everyone as equal. So objectors were given the opportunity to present on February 4th to approach. If they needed more time, they were given the time that they requested with the restriction of our calendar. And so within that time, it's the expectation that parties would put their case on. If parties have specific requests for keeping the record open, I will entertain those as they come up. But there's no general opportunity to leave records open for objectors, recognizing that we have 400 objectors and that leaving the record open for everyone would simply be unwieldy. There have been specific requests for items, and
Yeah.
those have been entertained, and in some cases granted, some cases denied.
Okay. Maybe we can take that up at the end of the presentation today or tomorrow? Or?
Unless you have something specific to do now, I would suggest doing it once we're at the end there, and you can tell me, because I have to consider specifically what it is.
Okay.
But it's also your case, so you.
Okay. Okay.
We haven't even started yet, so talking about what we're going to leave the record open for seems a little unwieldy at this point, but I leave that to you.
Okay, and then we had a final assessment hearing brief that we've handed up to you, which I believe is inside that first notebook on your desk. And I guess, oh, sorry. We've got a final assessment hearing brief that we've submitted, and so just to make Your Honor aware of that, in there is a request for continuance, an ongoing request for continuance to keep the record open. And we will, I guess, to let you know just this morning, I'm planning a sort of a summary presentation. There are a number of exhibits that go with that, and then we can admit those either as we go, or we can admit them later. I know you like to keep things in order sometimes, and Anthony Gibbons, who will be going first, a number of his exhibits appear first and aren't necessarily referenced in the summary materials I'm going to go through to get us started and to lay the background. So just wanted to defer to you as how you wanted to handle that.
If we can get some efficiency by adopting what you've presented, we can do that, but I don't know if does the city have a copy of what you've presented?
Yep, they've got a box of the exhibits and everything, yep.
Okay. And so you're proposing, what I've got as a notebook in front of me now that has tabs 1 through 12.
Mm-hmm. And you should have 5 notebooks total, up to about number 57.
So we have got a cart, so I'll get
Okay.
it set up here by me.
Okay.
Are you proposing to try to introduce all notebooks at the same time, or what's your proposal?
I could
can
do that
respond to your
right now
proposal,
and just
but-
say, we'd like to introduce all of our notebooks right now.
Is that your intent?
Yeah, we're hoping to we want all this in the record, yeah.
Okay. City.
Well, we just received this when we came in today, so I would like to reserve the opportunity to object to any exhibits. At this point, it'll take us
It
some
does
time
seem
to-
unwieldy to simply admit
Yeah.
half
yeah.
a dozen notebooks,
Yeah,
so
yeah.
I'll have to deny that request.
Okay.
Did you have another proposal of how you were going to proceed
Well, we
with
can
it?
just do it as we go through them, if
Okay.
you like.
Then we'll do that. Just to address up front, if you've requested just a general continuance, just to keep it open for the sake of whatever happens to be coming, but it's not specifically identified, I have already denied those requests for continuance. So
Yeah.
if that's what you were alluding
Ours
to.
are most specifically to consulting experts, because we know the city is very concerned that there has to be experts presented on various topics. And we've got an architect consulting, we're working with other property owners on other experts that will offer discrete testimony on particular issues around the plans and specifications, the cost estimates, the green spaces, things like that, so that we can really understand what's being proposed, what the baseline condition is, what the actual LID is constructing, and those sorts of things. And
So
so,
are you talking about what you're going to be presenting in testimony, or what you're talking about? I was trying to address your request to keep the record open that you indicated you have in here at this time.
right.
So you've got a bunch of studies you're doing that you want to leave the record open?
We have experts we're trying to consult with right now who haven't completed their work and may bring their testimony in with the other property owners, in which case it'll be part of the consolidated hearing and we would just adopt them by reference. But I just want to make it clear that we're feeling really jammed. We've only had, 30 days. The city had a 2-page description of the before and after conditions before they released the final benefit study in the 1st of January, which had hundreds of pages of text about what they were proposing and renderings. And we've been going through it as mightily as we can, but we're not all the way there yet. And so that's our concern.
Okay. I get, since I don't have a specific request, it's hard for me to tell you what's going to happen, but you could end up at the end of your hearing and not getting continuances on those items.
Okay.
So, because I don't have a specific request on those, I can't tell you how you're going to.
Well, I can tell you it's an architect who's looking at the open spaces and green space question about what is the landscaping.
So that's not going to be presented within the next 2 days?
Correct. I mean, I'm trying to get that presented, but I don't know that he's going to get done in time.
Okay. So it sounds like you're not sure what will be presented in the next 2 days. and
Maybe we can reserve it for the end.
You can raise it at the end. I'm not going
Okay.
to reserve any.
Okay.
I would just raise it at the end.
Okay.
If you're planning on bringing something up in the next 2 days, there's obviously no need for a continuance.
Okay.
If you don't bring up something, if you know that you can't bring it up now, you know that this is something you're going to reserve, you could raise that at this time. It doesn't sound like that's what you're asking, and so you can raise it at the end. I am just cautioning you right now or at the outset, you have 2 days.
Yeah.
You had 3.
Yeah.
I recognize you had a scheduling conflict, so
Yeah.
you didn't take advantage of the third one. But
Yeah.
you have the time you've got to present your case. And so parties have generally not been allowed to simply leave the record open for items that they weren't prepared for at the time of their hearing. So
I would say that things we know we will not be able to present by Wednesday will be cost estimation testimony, engineering testimony, and planner testimony. Though I I may be able to get the architect in. So we know that that won't happen, and we're working with other property owners to get that evidence into the, what I understand to be a consolidated proceeding, consolidated hearing.
It is a consolidated hearing, and you can, by reference,
Mhm.
adopt what other individuals
Okay,
are doing.
yeah, so that may take care of a lot of our issues.
Okay.
Okay.
Just recognizing that those individuals all sort of have their own set times as well.
Yeah,
So
yep.
if you're working with somebody who's got 45 minutes and they haven't put their own case on, and
Yeah.
maybe you're slipping in a architect report into
Yeah.
that probably won't work.
Yeah, yeah.
So I don't know what you mean when who you're slipping it in with, but,
Right.
all right, sounds like we'll take that up at the end.
Okay.
Okay.
Thank you. And so on your, there should be a stack that looks like this that you have up there, Your Honor. These are the sort of the opening statement summary presentation of background information we're going to start with.
And are these seem separate from your notebook that was labeled?
Correct.
All right, so we've already got our labeling off, it sounds like, because we have to mark these as an exhibit?
I believe they have exhibit numbers at the end of our notebook. Numbers 58, 59, and 60.
All right, these will be marked as exhibits 1 through 3.
Do you have the one that starts with the city's appraisal is fundamentally flawed on the second page?
Yes, that's been marked exhibit 3.
Okay. We'll start with number 3. So, as an overview, we've got 4 sort of topics, big section items to go over with you during these hearings. First one is the appraisal is fundamentally flawed, and Anthony Gibbons will be testifying about that this morning. He's our first witness. The second big category of topic is the plans and specifications are vital and they're missing. And then the third is that the with and without scenarios really revealed there's no special benefits. And then the 4 is a variety of defects in the procedures, authority, jurisdiction of the City Council to do what it did, and those are largely dealt with in the briefs. And so turning to the first section about the city's appraisal being fundamentally flawed, on page 3 is Anthony Gibbons' resume. He'll be talking more about his background in a minute. On page 4, the highlights for the Macaulay appraisal is fatally flawed. We'll be hitting on the appraisal does not measure general benefits. The city's appraisal does not measure the before and after values. The city's appraisal assigns benefits. It doesn't measure and calculate them. The cost of achieving the before condition was not calculated and taken into account. The methodology, the city picked the LID boundary. Treatment of vacant land is inconsistent and inequitable and versus improved property types. The city's appraisal is within the margin of error for an appraisal. It anticipates a value lift of 3% when the usual margin of error for an appraisal is 5%, and so it's speculative. And it also makes a number of incorrect assumptions about the status of the plans and specifications, the waterfront conditions, and the LID improvements themselves. To highlight the critical analysis around what is a general benefit versus what is a special benefit. The distinction between general and special benefit is critical because if we don't do that, then properties are assessed for general benefits when they can't be. Total benefit minus general benefit equals special benefit. That's the formula we're looking for. Here, the before assumes the viaduct is down and the streets are restored, but the city's appraisal doesn't really take that cost or take that into consideration as well as it should. On page 5, special benefits, they're different from and must be distinguished from the general benefits. It is unconstitutional to tax a subgroup of local property owners unless there are special benefits. And the purpose of the waterfront LID improvements is to provide general benefits. Special benefits are different from and must be distinguished from the general benefits. It is necessary to allocate the beneficial effects of the project enhancements between special and general benefits and to consider only the special benefits in estimating the value of the property in the after condition. This is the law that's governing these proceedings. On page 5, special benefits are described as that which is substantially more intense to the property which is assessed than the rest of the municipality. And in Heavens, the court said, all such assessments have one common element. They are for the construction of local improvements that are pertinent to specific land and bring a benefit substantially more intense than is what is yielded to the rest of the municipality. Pertinency is rooted in due process and takings law. It is rooted in appraisal science. And while the RCW has, over the years, and some of the case law said that direct appurtenancy is not always necessary, it should be remembered that that is the exception and not the rule, that the rule is generally that the improvements must be appurtenant to the land. According to the 2016 FEIS, the purpose of the waterfront LID improvements is to provide general benefits. It's a series of infrastructure improvement projects planned along the Seattle waterfront in response to opportunities, transportation needs, and related public objectives created by the removal of the Alaskan Way Viaduct. It's a new transportation corridor. It's a new pedestrian connection. It's public open space. The Pike Pine improvements and Pier 58 were not dealt with in the FEIS, and special benefits to private property owners are not included in the project purpose.
And Council, I just want to note that the copy I have received
Oh,
has,
sorry.
the pagination is off.
Yeah, sorry about that.
I've got double numbering here on a couple pages 6, a couple pages 7, 2 pages 8. So it's just off in this copy that I've got.
I'll get a copy that looks like yours going next to me.
And maybe what I can ask you to do is if we can get a substitute copy
Yep.
for Exhibit 3 for the final.
Yep. Sure.
With the correct
Yep.
numbers.
And so nowhere in the FEIS are special benefits to private property owners included in the project purposes. On page 7,
I'd skip the numbering.
okay, next page.
It's not going to make any sense.
And so we introduced the exhibits while we go. Let me see. That was the first one. Exhibit 4 is just the local improvement road district manual for Washington State in our notebook.
So you're introducing
We'd
exhibits
offer that,
now?
yep.
Not through a witness?
Well, we had just talked about introducing them during the summary presentation, or?
I wasn't sure what you were
Yeah,
doing, so.
yeah.
And so these are not in order, these are just, you're going to go through
Well-
these and introduce them as we go, it seems like? Because we've already
Yeah,
got,
yeah.
these are different.
Yeah.
Okay.
Yeah, ours were at the back, and you put them at the
Okay.
front, yeah.
I'm sorry, I didn't hear what you said at the end.
Yeah, we're moving on to introduce Exhibit 4, the local and road improvement districts manual.
That's marked as Exhibit 4.
Okay.
Mr. Haying, Examiner.
Yes, ma'am.
I just want to get clarification on the record that this is opening statement and not being considered as factual testimony as part of this proceeding.
You're asking me or council?
I'm asking you. I assume that council.
I'm not entirely clear in some of the statements, so
Yeah.
I can't answer it for you.
Okay, so are you providing fact testimony or a summation of your argument?
Mostly a summation, but we considered these summary proceedings, so we don't have like a witness for every single exhibit of just city documents and things like that. So we're offering those as part of the summary proceedings. The court could take judicial notice of it, or?
Well,
I don't-
I'm not going to take judicial notice. I'm not going to mark a bunch
Yeah.
of exhibits through judicial notice, but if the issue is simply exhibits, sometimes we have allowed those through counsel for
Mhm.
judicial efficiency.
Mhm.
If that's what you're asking, we
Sure.
can entertain that, but you need to ask.
Okay.
And let us know that's what you're doing.
Okay.
As far as the rest of your testimony, your statement, though, is not factual testimony. Is that correct?
Correct, no.
Okay, but you are through counsel seeking to introduce some exhibits.
Correct.
Okay. Does that clarify?
Yes, thank you.
Seattle's Waterfront for All. So according to the mayor and the Seattle Department of Transportation, the purpose of the Waterfront LID is to benefit all. Seattle's new Waterfront for All, that will include 20 acres of public spaces. Everyone stands to gain from this shared investment in a great public space. We would introduce Exhibit 6 and Exhibit 7. Exhibit 6 is Mayor Durkin's announcement of the Waterfront LID legislation. And Exhibit 7 is a copy of the Friends of the Waterfront website, where they proclaim they are building 20 acres for the public, by the public.
These are marked as 5 and 6. And what I'm going to ask is, since I don't know how many of these there's going to be, is that we address admissibility at the same time as we're marking them. So counsel for the city, be on notice that if you're objecting, if you have an objection to any of these coming in, please raise it. I defer to you to do that.
Okay, thank you.
Otherwise, I'm assuming I'm admitting and marking at the same time. Typically, when it comes in, I just mark, and either by my own volition initiate somebody admitting them, or somebody does that on their own. But in this case, since it's just coming in, I think we could do it faster by assuming that it's marked and admitted unless there's an objection.
Thank you.
Oh, Exhibit 5. Yes, and then at that point, let's offer and admit Exhibit 5, which is the final environmental impact statement.
The final what?
Environmental impact statement.
Do you want to move up here at the break? Okay.
You can keep kicking me to talk louder.
That's marked as Exhibit 7.
So the city would like to place a just standing objection related to any SEPA issues or SEPA documents that are presented or admitted in this proceeding. This proceeding concerns the assessments for the lid, and compliance with SEPA is not relevant to this proceeding. We understand that parties may wish to admit certain exhibits or make argument about SEPA, but we would just like on the record that the city considers that to be irrelevant to this proceeding.
Any response?
Well, we do think SEPA is relevant to the proceedings, Your Honor. The City Council has a duty to perform SEPA before adopting the final assessment rule, and that is one of the recommendations we'll be seeking from you, to find that they need to do that and recommend that the City Council complete SEPA before adopting the final assessment rule. It's also really critical in understanding the challenges the city's having with the plans and specifications. SEPA is required in order to develop the plans and specifications, and to date, that work has not been completed.
All right. I don't yet know the nature of the SEPA arguments that are going to be presented by various parties. They're ranging. Some are procedural, saying they must comply with SEPA, and so procedurally there's an issue with a waterfront assessment LID. I don't know if that's a valid issue yet. I haven't heard argument on it, essentially. I've heard people maybe trying to raise arguments about compliance with SEPA and starting to talk about significant impacts. I can tell you now that's not part of this hearing, but people may try to do that. But I'm not going to rule on it simply because it's a wide-ranging issue, and I don't know what future arguments are going to be. The city's objection is noted. I simply can't rule on it at this time because it's too broad. It's not on a specific document. It's on an argument that parties may present. And so I'm going to defer any decision I make on that to my final determination.
And I do think the 20 acres of public space, green space is important to note. You know, this isn't a situation where there's large grassy areas like Myrtle Edwards Park. It's a promenade made for moving crowds up and down the sidewalk, and people won't be able to hang out in the median, in the street, so to speak, to enjoy the trees. The Waterfront LID, the Central Waterfront, was compared to Golden Gate Park. It was compared to Vancouver's Stanley Park. We would offer Exhibit 8 and Exhibit 9. Those are statements made by Marshall Foster, Director of the Office of the Waterfront, and by Mayor Durkin.
These are Exhibits 8 and 9?
In our notebook, yeah.
No, in our record.
Okay, yours too.
They happen to have matched up at the time.
Council members Johnson, at the vote on the formation ordinance, called the new space for pedestrians as opposed to a place for cars. And Councilmember Bagshaw said it would be green and not gray. And we offer Exhibit 10 regarding the transcript for the January 28 formation hearing.
That'll be Exhibit 10.
In reality, Alaska Way is a major truck route and a transportation corridor. It is what's been described as world-renowned planners as a poor environment for pedestrians. In 2009, Gell Architects was hired by the state of Washington, King County, and the city of Seattle when analyzing the deep bore tunnel option, and they found the surface streets created on the waterfront would create a poor environment for pedestrians, and we would offer Exhibit 11, the letter from regarding Gell Architects, and then their report, and then some speaking points that SDOT crafted in response to their study.
Yes. 11, marked as 11.
And then we would also offer our Exhibit 28, which is a letter from the Seattle Commission for People with Disabilities regarding the same challenges navigating the roadway.
That'll be marked as 12.
We would adopt by reference the number of the amounts of testimony that you've heard regarding property owners and residents' personal experience with visiting the waterfront and not visiting the waterfront. For the most part, local residents don't enjoy the resident and don't plan to use it any more in the future than they do now. And after deciding to do the local improvement district in 2013, the city hired HRNA advisors to conduct a downtown visitation study, and they found or assumed that downtown residents would not use the waterfront any more than they would today in the future. And that's our Exhibit 12, and we would offer Exhibit 12.
Marked as 13.
And so, on to what might be page 9 now in the presentation, as a photograph of Stanley Park next to the waterfront. This is not Stanley Park. The next page has a similar contrast between Golden Gate Park and the Central Waterfront. This is not Golden Gate Park. In reality, according to the FEIS preferred alternative, I think this is on your page 11, Your Honor, Pine Street to Union Street is a 6-lane roadway, And we would, in addition to Exhibit 5, offer Exhibit 13, which is the excerpts from Volumes 1 and 8 of 8 drawings for the Alaskan Way, Elliott Way, South King Street to Bell Street main corridor drawings. We're still working with K&L Gates to confirm that these are the main corridor drawings, and when we have bait stamps numbered, if they're any different, we'll deal with that with Your Honor at that time.
So which are you seeking to, which?
Exhibit 13.
So we're going through all of these different notebooks now, is that right? Seems.
I don't know if we'll get through all of them. Not, the presentations don't touch on every document,
Okay,
so.
I just wonder if we
Yeah.
can maybe consolidate this and be more effective than me opening a bunch of notebooks. All right, that's 14.
Mhm. Uh, 14 was number 13, R13, the excerpts of volumes 1 and 8. And so I think it's now, yeah, turning to your page 12. Union Street to Spring Street is a 6-lane roadway. Madison Street to Yesler is a 7-lane roadway. Alaskan Way north of South Washington Street is going to be a 9-lane roadway. That's from Exhibit 5 and Exhibit 13. Alaskan Way north of South Washington Street at the crosswalk is an 8-lane roadway with a pedestrian refuge center. And Yesler Way to South King Street is an 8-lane roadway. I think it should be your page 18, Your Honor. We have a map of the American Life properties at issue here this morning. This map was taken from the formation ordinance, and so we would offer Exhibit 14, the formation ordinance. Exhibit B in particular is the picture.
I couldn't hear what you said.
Exhibit B to the formation ordinance is the picture in this diagram.
Exhibit 15.
Yes.
Thank you. This will be highlighted by Mr. Gibbons' testimony, but one thing to point out on this image is that it appears to us that it misrepresents the length of the improvements on South King Street. The improvements are proposed to end at First Avenue, not Second Avenue, and so we just wanted to point that out. The next few slides are just some photos of the various properties at issue here this morning. 255 South King Street. We have a couple different images there showing the landscaping around the building and the improvements made when it was built. 618 Second Avenue, which is the Courtyard Marriott at Second and Cherry on page 21 there, has mature landscaping and sidewalks in front of it. And then on your page 22, 1000 and 116 First Avenue South, these are adjacent to the stadium, contiguous to each other, but quite a distance from the improvements. There's a couple more photos for you on page 23 and page 24, just to give you some reference to the properties here at issue today. And then that's the end of that one, which I believe is your Exhibit 3.
Yes.
The next one I'd like to highlight is the one that starts with plans and specifications are vital and missing.
You have 1 and 2.
It's number 2. Is it 2?
It's 2. just want to make sure I've got the same pages as you, Your Honor. So, a big part of what we're going to be talking about over the next day or two, and Mr. Gibbons will be highlighting this a little bit himself, the plans and specifications really are vital, and they're missing, quite frankly. The compliance with the plans and specifications are required by ordinance specifically. The city will say that plans and specifications means 100% design documents. And we know from LID law that the foundation and purpose of the LID must be achieved. And so it's really important that we have really good plans and specifications so we're all on the same page about what we know is being built. What we've found to date, since the city released its study in January, is that there's still several inconsistencies exist regarding the without LID baseline and the with LID improvements. Most of the LID improvements do not add anything particularly different or special from the before LID conditions or without LID improvements. The overlook walk design in particular has been materially and substantially compromised. Many of the apparent improvements appear to create substandard conditions. The improvements depend upon a high level of operations and maintenance that is uncertain at best. The improvements are not appurtenant or contiguous to the 5 Pioneer Square properties at issue today and on Wednesday, and they are not so with most others either. And we are recommending 0 assessment for the property's owners here today. LID Formation Ordinance 125760 says that the purpose of the, wait, I'm reading the wrong thing, sorry. The Formation Ordinance requires compliance with the plans and specifications, and they may be modified by the City Council as long as such modifications do not affect the purpose of the LID improvements or constitute materially different improvements. Accessibility here is a major issue. Accessibility is one of the foundations of the Central Waterfront program, and you'll be hearing more about how accessibility still remains a challenge for the city on this project. Have we offered Exhibit 14, the Formation Ordinance? That's in right now is 15, right? Okay. The city in Exhibit 29 agrees that and will say that the conformed set of plans and specifications of each waterfront LID improvement as prepared by an outside engineering firm hired by the city after the waterfront LID improvement has reached 100% design. And so we would offer Exhibit 29.
It's Exhibit 16.
Thank you. And according to the City of Seattle, the plans and specifications and construction will not be complete for, quote, several years and are, quote, subject to change, end quote. We would offer Exhibit 30.
You're referencing responses to
City-
Discovery?
Yep.
Could you just state for the
Yep.
record which response you're referencing?
The second set. The Exhibit 30 is the city's objections and responses to plaintiff's second set of interrogatories.
And what numbered response are you referring to?
32. Wondering if there's a typo in there. I think this is your page 4, Your Honor. The percent of designs.
Let's wait.
Okay, are you still
Sorry,
looking?
I'm reading.
Okay, yeah, sure.
So you said this was,
And it might be actually.
is this
third and fourth.
interrogatory number 32 to your, it's marked in this binder as Exhibit 30?
Let me get the, because I know the third and fourth have it too. We might have a typo in there.
Did you have an objection, Council, or do you need a minute?
Do you
or-
need a minute? or-
Sorry, I was just reviewing. No
Yeah.
objection.
Okay. Then we've got Exhibit 17.
Okay. The percent of design, in terms of the plans and specifications, is something that's certified by the appraiser. I'm on page 4 now of your handout, hopefully. The preliminary city appraisal relies upon the improvement designs and costs to calculate increased values. The final city appraisal relies upon the improvement designs, percent of design and cost to calculate increased values. And the city's appraiser certifies the appraisal as accurate. The preliminary city appraisal relies upon the improvement designs and costs. This is Exhibit 36, which is the Val Bridge preliminary study, which we would offer at this time.
Which exhibit of your?
My 36.
And what is this?
This is the preliminary study, the Val Bridge preliminary study.
Exhibit 18.
Next, we would offer our Exhibit 18, which is the final benefit study.
And this will be 19.
The percent of design and cost estimates really go hand in hand. Throughout the RCW and the appraisals, the cost of the improvements is a key factor in determining their value and the impact they have on property around them. At the same time, cost estimates are driven by the percent of design and where we're at. And here, we'll be seeing that the percent of design remains unknown, that the cost estimates are not complete. And so this is a fundamental, issue with the overall appraisal. The city's with and without scenarios in the final appraisal are extraordinary assumptions made by the city appraisal. That's on page 28 of Your Honor's Exhibit 19. And use of preliminary plans, which is what happened here, requires a new appraisal once the plans are done. And that's, again, Exhibit 19, page 91. I think we're on to your page 5. Just some background information we have on the percent of design that science, for lack of a better term, that the city uses. This is from our Exhibit 32, which we would offer now. The Waterfront Seattle Waterfront Park Improvements 30% Schematic Design Update for Pier 58, which is one of the LID improvements. Appendix E. I think it's 20 now.
Exhibit 20.
Something I'd like to note here, Your Honor, is that concept level designs come before project definition, and we'll see how this becomes an issue, in particular with the Overlook Walk. 30% schematic designs can mean just 5 to 7% designs. And this project definition is important because, for example, with the Overlook Walk, we're losing elements. Elevators are being eliminated, staircases are being eliminated, and so we know we're not quite to project definition because the project keeps changing. The next page in Exhibit E, which is on your page 6, shows the risks associated with the different levels of cost estimating and how it is that this will become relevant both in terms of making budget decisions that are binding future councils and future budgets, because we don't have solid designs and so we don't have good cost estimates, but it's also an underlying aggravating factor of why the appraisal remains fundamentally flawed, because it's based on an incorrect assumption about where the plans are and what we actually know. I have a short timeline here on page 7. As you may recall, Bertha stalled from about December 2013 to December 2015 while the city kept making plans for the central waterfront. The Office of the Waterfront, though, it may have misrepresented the percent of design status both in 2015 and 2018. And then we just recently, in the last week, have uncovered that the city appraisal incorrectly relies on SDOT's claimed percent of design without verifying the accuracy of those statements. In Exhibit 33, which we would offer right now, the 2015 work plan of the Office of the Waterfront. The Office of the Waterfront claimed for its 2014 accomplishments that 30 to 60% design milestones were achieved for the main corridor, the Overlook Walk, Public Piers, and Union Street.
That'll be Exhibit 19.
19?
Sorry, 21.
Thanks. In the third quarter of 2015, the Office of the Waterfront set out its pre-development plans for 2015, and at that time it predicted the Overlook Walk would be at 90% in 2018, Union Street at 90% in 2017, Pine Streets at 90% in 2017, and Pioneer Square at 90% in 2018. That's Exhibit 34, which we would admit right now.
The Exhibit 22.
On your page 8, we have a comparison of the Overlook Walk and Ocean Pavilion presentation that the Office of the Waterfront made to the Seattle Design Commission, claiming it was at 30% design in April 2018. In the minutes from the Seattle Design Commission, that was not the case. In the approved minutes, the Overlook Walk is at concept design, which is 2% only. The Seattle Design Commission identified waterfront landings access issues, that vegetation will block views, that they should increase the elevator capacity to be reliable and meet the expected demand, that adjacent stairs need to be more appealing to their users, and they identified equity issues involving accessibility, restrooms, and the tribes. We would offer Exhibit 35, the Seattle Design Commission minutes, or Exhibit 27, which is the minutes, and then Exhibit 35, which is the presentation.
27 and 35, your
Yep,
27
my
and
27 and 35, yes, Your Honor.
Your Exhibit 35 is marked 23. And the next item is marked 24.
In May 2018, the City Council votes to adopt the resolution of intent to form the Waterfront LID, while the truth hides in plain sight. The Seattle Design Commission minutes reflect, for example, that the Overlook Walk is only at concept design, which is about 2% by the city's own documents, and yet the summary from Macauley's preliminary study shows that the Overlook Walk is approximately 30% completed. The Promenade is 90% complete. Union Street is approximately 30% completed. Pioneer Square less than 10%, and Pike Pine Streets are at 10% completed. And that's coming from the Val Bridge preliminary study, which you already admitted, pages 2 and 3. On page 10, we have the latest update. The city is still not being forthright with where the plans and specifications are. The Macaulay final benefit study found that the Promenade is 100% complete. The city's answers to discovery agree that the Promenade is 100% complete. The Macaulay final benefit study says that the Overlook Walk is 30% complete, but the city has said that actually the Overlook Walk is unknown. It's anything less than 100%. Union Street is at 90%, and the city says Union Street's actually at 100% now, and we're waiting on those plans. Pike Pine Streets are less than 30% versus Pike Pine Streets are unknown. Pioneer Square is less than 30% versus the city saying Pioneer Square streets are unknown. Pier 58 is 30% complete, but Pier 58 status is unknown and something just less of 100%. Macaulay says that the designs will not change substantively once this 30% milestone has been reached, whereas the city is telling us that all designs, plans, agency reviews, specifications, and construction documents are still in progress and subject to change. And we would offer Exhibit 29, the city's objections to the third interrogatories. Oh, see, that was a typo then. That's probably why you got lost on the other document, because it was a typo. But there's a better reference for you right there, Exhibit 29, pages 12 and 13.
That's now Exhibit 16.
That's 16 now? Okay. And we would offer Exhibit 15. I think it's important to note that one of the consequences of not really having a handle on the Overlook Walk design is that the budget at the time the city formed the LID was $100 million, but in the latest adopted capital improvement program, the Overlook Walk is now estimated at $174 million.
Marked as 25.
Thank you. And then lastly is just an update. This comes from a document authored by Marshall Foster in the Office of the Waterfront, our Exhibit 21, estimating the different number of permits and approvals and requirements needed. We would offer our Exhibit 21.
Exhibit 26.
And then our Exhibit 37. I don't think we've done yet. We'd offer Exhibit 37 too as well, Your Honor.
That'll be Exhibit 27.
Okay. And that concludes the second packet. Now we're on to the third packet, the with and without before and after scenarios. This one's one. Probably at the heart of the appraisal and the heart of the issue is understanding really clearly what is the before condition and what is the after condition. And so the purpose of these next few slides is to provide background and information on what really is being proposed by the city as part of the Waterfront LID. We have, of course, a number of other defects that we're concerned with that we'll be dealing with in the briefs, but we also want to spend a little time showing you the before and after scenarios so that you can have a good handle on the projects at hand. The first, starting off on page 3, the promenade. One of the things that's really important to note about the city's final benefit study is that the renderings are not to scale, and they don't always comport with the plans or the FEIS or other things. So while they're very beautiful, nice pictures, I just would ask Your Honor to exercise some caution because they're not always to scale. The baseline is significant without the LID improvements, and this will be part of Mr. Gibbons' testimony as well. One thing we have to take into consideration is the volume of activity that's happening on our waterfront and all the new improvements and infrastructure that's going in outside the LID. That is thus the baseline condition. And so, the seawall is replaced, the viaduct is removed, Pier 62 is replaced, there's a new two-way bicycle facility, there's a new Marion Street Bridge, there's a new Lenora Street Bridge, University, Spring, Madison, Marion, Columbia, Yesler Way, Washington, Maine, Jackson, and King Streets all have roadway and sidewalk access to Alaskan Way, and the original Pike Street Hill Climb, Union Street Stairs, and Seneca Stairs continue to provide pedestrian access as well. We have rebuilt the Washington Boat Landing. There'll be a Habitat Beach completed near the Coleman Dock. The main corridor is restored, which in and of itself was a $370 million project. The Belltown sidewalk and landscape enhancements. There's a new Elliott Way roadway. There's an elevated pine intersects with Elliott Way. The sidewalks, new sidewalks on both sides of the street and 2x2 scored concrete. Crosswalks with 6-inch curbs. The railroad way has been rebuilt with new landscaping. They're proposing 377, and according to the final study, they're saying that there's 377 new street trees at 1.5 to 2-inch caliper on both sides of the street and in the median, and that. But then we also have to compare the landscape planting schedule from the main corridor design. They're actually showing 320 or 823 trees, 660 large trees, and 163 small trees. And so this is, again, one of those issues where it's not really clear what the baseline is still, and we're trying to figure that out. And then hardy ground cover everywhere else you go. And so at this time, we would offer, I think Exhibit 15 was just admitted, Exhibit 16, our Exhibit 16, Exhibit 17, and Exhibit 20.
All right, that'll be right. 28, 29, and 30.
Thank you. With regard to the sidewalks in particular, the sidewalks as the baseline are proposed to be 2x2 scored concrete, but then the proposal is to remove these sidewalks and replace them with 2x2 exposed aggregate, and actually reduce the width of the sidewalks on the west side for additional landscaping. We would offer Exhibit 19, the addendum to the ABS Final Special Benefit Study. Well, we have the study itself, but I'm seeing the addendum here is marked separately in our book, so.
That'll be 31. Do we need this, Randy?
Yes, please.
Where are we at, Council?
I believe on your page 4, I don't know, do you want a break, or do you want to go for 15 more minutes, or?
How much more intro do we have?
I don't think a lot more. I think this will go pretty fast.
Let's try to get through that at least. then.
Okay. And so on your page 4, hopefully, the landscaping is substandard. They're proposing to limb up the evergreens, and it looks like from the photos, maybe even top them to maintain their small structure. This was confirmed by the landscaping schedule in volume 8 of the main corridor designs. It also appears from the renderings that the trees will not be spaced well for adequate growth and that sort of thing. The parking on your page 5 maybe now remains really confused. The baseline was supposed to have all the parking on the east side of the where the viaduct used to be, and now they're proposing that it be on the west side. I don't want to belabor the point, other than to point out that it still remains pretty confusing about what's going on with the parking. It's also important to note on page 6 that the renderings are not to scale and do not accurately reflect the number of trees. The width scenario for the trees is just to add 16 trees. The Waterfront LID is only proposing to add 16 trees to the baseline, but the renderings seem to show lots more than just 16 trees. This is an area, Your Honor, where I know we're going to be requesting, an opportunity to file a closing brief at the end of the proceedings, or at the end of when you close the record, sort of thing. And this is one of the issues that we're still grappling with, but this is just sort of a few things that we've identified to date in terms of some code compliance issues with what the city's proposing. A 6-inch curb is the standard, not 3 inches. Non-native species are generally prohibited in the shoreline environment and discouraged generally around town. Evergreens are not suitable for sidewalks and medians. They need about 35 by 35 feet to thrive and grow. And exposed aggregate is not necessarily, even though pretty and decorative, a better concrete solution, especially for a major truck corridor. And so we would offer Exhibit 22, our Exhibit 22, 23, Exhibit 24, and Exhibit 25.
31. What number? Where's 31?
31 is...
There it is. Okay, so this will be 32, 33, and which was the last one you did for you? For your
My
numbers?
25?
Okay. Got 34 and 35.
And then we just highlight the 6 projects really quickly here for you, Honor, so you can see for yourself the before and afters right next to each other. The first is Union Street on page 9. The before is
And just note the pagination's off on this one.
Oh,
as
okay,
well.
sorry. Union Street has a without LID and with LID photo there for you to look at the comparison. And then the next project we have is the Overlook Walk. The Overlook Walk has been on a diet, I refer to it as. This particular before and after of the Overlook Walk shows you without the LID and with the LID per the 2016 FEIS, the original concept with the large lawn area in the middle. And then when we get further into it, however, we start to notice that the Overlook Walk starts to go on a diet after the resolution of intent is voted on, after the preliminary benefit study, and after the LID public hearings even. The Overlook Walk diet continued even after the formation ordinance, and we have renderings or images for you that show what it might look like now per the final special benefit study. Things to note, I think, are that the lid deck span has shrunk from a large rectangular shape to an hourglass shape. There used to be multiple staircases to access the promenade in 2016, 2 elevators, public restrooms under the staircases, and the lid elevation for the deck was about 40 feet above the promenade. By the time we get to 2018, the lid deck has been reduced to an hourglass shape. It has 2 horseshoe configured staircases running from it. No new elevators. The elevators have been eliminated. There are still public restrooms under the staircases, and the LID elevation is now approximately 50 feet above the promenade. And we would offer Exhibit 26, which is the new Overlook Walk EIS reevaluation that SDOT did for the Overlook Walk in September 2018.
That'll be 36.
When we get to the final benefit study, released just this January, there is only 1 set of horseshoe staircases on the north, it appears, that will be built. There are no new elevators. The restrooms have been eliminated, and the LID elevation is approximately 46 feet above the promenade. If you turn to page 13, there's an Overlook Walk 2.0. Maybe it's, yeah, it's your 13. Hopefully, looks like this. This is not, I'd like us to pull out Exhibit 19, the final benefit study addendum. I think we just did that one, and it was 31, yeah. Yeah. I'd like, Your Honor, just to look at this page.
I'd just go ahead.
Okay.
Since you're not giving testimony,
Okay.
me going through the documents
Okay.
right now doesn't
All right.
really
That's fine.
make much sense.
Code compliance issues with the Overlook Walk are Seattle Design Commission approval, and elevator and ADA access and other things like that. And we would offer Exhibit 28. I think that's been admitted. Okay, that's number 12. Okay, that's already in. Pier 58 is the next LID improvement. Pier 58 is an existing park pier that's been around for quite some time, and the new park pier is proposed there. You can see it on the water. There is some concern with the overwater coverage and use of this area, both in the FEIS. The tribes commented that they would like the city to keep open the option of restoring the natural shoreline and the restore the habitat as an option. And again, this is why SEPA is important to do before you decide on your project. And just wanted to flag that for you, that that's out there. And we have an exhibit for that. It's not here. Exhibit 51, our Exhibit 51 we would offer now, which was the tribal comments, Suquamish tribe comments to the FEIS.
These are 37.
And we'd also offer our Exhibit 50, which is an excerpt from the Central Waterfront Master Parks Plan, which similarly called for demolition of the pier and restoration of the shoreline.
38.
Pioneer Square, I think we have some before and after renderings to help familiarize yourself with what the before and after is. And it's, Anthony Gibbons will touch on this as well, that it's just not a lot being proposed here. It's hard to tell the difference between the before and after, quite frankly. And in the case of King Street, which is the only street in Pioneer Square that comes close to one of the properties at issue today, the only proposal is to plant 2 trees 2 blocks away from the building. And I think we're pretty good at this point. The city did propose striping and some improvement on Second Avenue, which was not part of the formation ordinance, and so we are going to be asking that that be removed from the LID. The Pine Streets, similar to Pioneer Square, still early in the development, and not sizable in terms of a lot of that they're adding to the streetscape. Some trees and taking existing planters and putting them in the ground. Appears to be the majority of the proposal for those. I guess in closing, just for 1 minute, Your Honor, it sometimes feels to me somewhat like a rule of law issue with SDOT. The SDOT and the City Council need to do SEPA review, and they need to develop their plans and specifications in accordance with standard procedures for developing plans and specifications. Our environment, our race and equity, social goals really demand that. They need to lean into the Seattle Design Commission's recommendations and not away from them, and they need cost estimates that are concrete and will not bind future city councils unlawfully. And they had a duty, because it's a park, to comply with a different LID structure, approval process for approving a park LID. I sometimes liken it to, going to the bank for a loan when you're trying to develop a property. You go in for your pre-development loan and you get a small percentage of the overall project, and the goal is to hire your architect and get some drawings and get a permit. And then when you get your permits, you can go get your construction financing. But here, and then maybe after you construct your building, your projects, you can close out your financing and refinancing. But here we haven't finished step 1, and we're already into step 2, and the designs are being compromised while costs keep going up. And now there's even, a lot of just gray about what actually is going to be built, and yet this is the foundation of any local improvement district. We have to get this straightened out. We have to daylight this, and we have to know what's actually going to be built. It's not just these property owners before you this morning, or even the 6,300 property owners out there in full, but I'd say it's everybody. It's the city council, it's the tribes, it's our community, that we use these proceedings to really get to the truth. That's it.
Thank you. We will take a break and return at 10:30. And we return to the record with objector's case in chief.
The objectors call Anthony Gibbons, please.
Good morning, Mr. Gibbons. Please state your name and spell it for the record.
Excuse me, can we get these people to stop talking about this?
Anthony Gibbons, it's Anthony with an H, and Gibbons.
And you just need to speak up. She needs to get it, and then the mic. You don't have to. The
Okay.
microphone. This is for everybody. Make sure that you have a microphone within about a foot of your mouth. This is purely for recording purposes. It doesn't assist anybody hearing.
Okay.
So if you want others to hear, like the court reporter, that's where you need to project your voice. So.
Okay.
And thank you for stating your name. Do you swear or affirm the testimony you will provide in today's hearing will be the truth?
Yes, I do.
Thank you.
Good morning, Mr. Gibbons. I know that our hearing examiner has worked with you before, but let's go through your background just a little bit. Can you tell me a little bit about your professional background?
Sure. I've been a real estate appraiser since 1983. I'm a member of the Appraisal Institute. I'm a former member of the Councilors of Real Estate. I've been president of our local Seattle chapter of the Appraisal Institute, and also of the counselors. I published in the Washington State Bar Association Handbook on Appraisals. I wrote that chapter, and I'm also on the Runstad Center Advisory Board for Runstad Center Real Estate at the University of Washington. And I also teach in their class. They have a commercial real estate certificate, and I've taught that class for over 15 years, and I was the lead instructor in the class in Tacoma, UW-Tacoma, during the years that they held the course there.
Okay.
Yeah.
There should be a box of binders down there to your right.
Okay.
If you could pull out the binder that contains Exhibit 1.
Yeah.
Is that a current copy of your CV?
Yes, it is.
We'd like to offer Exhibit 1.
Okay. I need to see the sheet. Marked as Exhibit 39.
Mr. Gibbons, have you ever done any work on behalf of the city of Seattle?
Yes, I was asked by the City Council to look at an economic analysis of downtown zoning when the city was interested in rezoning downtown to accommodate higher height limits. And as part of that, they wanted to institute a program where there was affordable housing payment, basically, for higher density zoning. And so I worked on that economic impact study with Heartland, testified in front of the City Council on the project, and we also met with numerous developers undertaking various feasibility studies to test the model that we are working with. I've also been an expert witness for them in several cases, landslide cases and damages cases.
Okay. And were those cases pending in King County?
Yes, they were, yeah.
Have you done work previously related to special benefits?
Yes. I wouldn't say it's routine, but it feels almost routine. We do a lot of condemnation work And as part of that, we're required to look at the potential for special benefit. This has become an issue, particularly with light rail construction, and so we've had a couple of cases where either the agency has alleged special benefit for a particular partial take of a property, or we've done studies of looking at the potential for special benefit for those. I also, so as part of that work, I've spoken at least a couple of times in a seminar with the Washington State Bar Association on special benefits and general benefits, and we're giving a talk actually this coming May on that subject matter for that.
Have you done any other special benefits work relating to parking or other improvements?
Yeah, I did for the city of Bainbridge Island, I did a preliminary look into the potential feasibility of a LID for the construction of a parking garage downtown. Basically defining the boundaries of what the LID would be and what the potential benefit would be.
And just to follow up, and so in that project, you were the person who determined the boundaries of the
Yes.
LID?
Yeah.
And how did you go about doing that?
I looked at, unfortunately, we're not very good at walking in this country, okay? So the distances that people walk from their car to a retail store are, there are several studies on those and how far people will park, and obviously I knew that community very well, so I could see where people would tend to park to walk to store buildings. So we looked at various distances that would be created if the parking garage was central parking, how people would go park and then walk to retail businesses, and how much those would benefit.
Okay. And what was the conclusion of your study?
Basically, there wasn't enough benefit there that I regarded as special to make that LID feasible.
And did the city agree with your assessment?
They took my recommendation, yes.
Okay. We're here today to talk about the special benefit study prepared by Bob McAuley.
Yep.
Are you familiar with Mr. McAuley and his work from prior cases?
Macaulay.
Macaulay.
Macaulay, yeah.
Really struggle with that name.
That's all right. You can't look at it. Yes, I am. I'm familiar with Bob McAuley. I've known him for a long time.
And have you worked with him before?
We've been on opposite sides of an arbitration before, so yeah.
And are you familiar with the studies that he performed here?
I am, yes.
And how are you familiar with them?
I've actually been familiar with the study for some time. I own a condominium downtown, and so really way back as early as 2012, Bob McAuley wasn't involved back then. It was a different appraisal firm. But I've been watching this project progress. And, of course, when the preliminary assessment came out, I reviewed that report. I was hired by BOMA, the Building Officers and Managers Association, so that's BOMA, to look at the study and provide my thoughts to that group of managers, of which basically representing most of the downtown high-rises. And then I attended most of the Waterfront Seattle meetings where where basically questions were presented to the Waterfront Seattle team headed up by Marshall Foster at that time. And the people could ask questions and delve into some of the details of the study.
And did you ask questions at those meetings?
I did, yeah. I think just one. I was perplexed as to the lack of detail regarding both the before and the after condition and the differences. The subject LID is unusual in my experience for an LID. Typically, an LID is reserved for a tangible improvement like a sewer line or a water, a sidewalk or curb front improvements. The idea of it being used for an aesthetic, like a park, is unusual. There are various reasons for that, which we can go into, but some of them are operational, how the park is operated, not necessarily what's in it or how it's constructed, and also how proximate it is to various properties. So when I saw the initial study, I felt like it was, frankly, an overwhelming project. The number of properties, how the variety of types of improvements in downtown Seattle, the value of those improvements, just high-rise real estate, and the linear nature of the park. And I just felt there were some overwhelming issues with trying to make a local improvement district out of that type of project. My specific request to Waterfront Seattle in one of these meetings was that they, up to that point, I think there were maybe 3 or 4 images of before and after images of the park. They had the viaduct in the before images, and then they had the park in the after images, and these were clearly inaccurate presentations of the before and after. And so I asked specifically that the city produce side-by-side drawings, which had not been produced at that time, even though the preliminary assessment had come out. And they had not produced these images because I felt they were important. I was questioned as to why the city should go to that expense. And I explained if the city was trying to assess an aesthetic, I was actually surprised that it hadn't already been done or requested, because how can you assess an aesthetic if you can't see it?
Right.
So that and in the final study, they've finally done that.
Okay, we're going
to some extent.
We're going to talk about that in just a minute. Can you turn to Exhibit 2 in your binder?
Yeah.
And is this the letter that, actually, let's turn to Exhibit 3. My apologies. Is that the letter that you prepared for as part of your BOMA work?
Yes. After attending those meetings, Jack McCullough asked me to prepare, and Catherine Sanford asked me to prepare a summary of my, basically my conclusions about what I'd seen so far in the preliminary assessment study related to that.
And we would offer this, I think, as Exhibit 40.
Yes. Yes, this is 40.
Did you receive any response to this letter? Or did anything happen as a result of this letter?
No.
Okay. And then after you prepared your initial letter in 2018, you were retained by property owners to represent the objectors at issue here, as well as others in the King County Superior Court litigation. Is that right?
That's correct, yes.
And have you provided any testimony in that case yet?
No, this is the first.
Okay. And you're also working with some other objectors who are currently represented by Perkins Coie, and you're going to be presenting testimony later in these proceedings as well, right?
Yes,
Okay.
that's my understanding.
What were you retained to do by these objectors?
Well, actually the first group that retained me was Waterfront Landings, and in that first case, they asked me if I would write a letter to the city inviting the appraiser. This is between the preliminary and final. Write a letter to the city inviting the appraiser to meet me on the site, and we could go through some of the issues that we had with the assessment, because as pertained to Waterfront Landing, there was no rhyme or reason to the assessment. It was very broad. It didn't take into account view blockages of the project or the location of the project. And so I wrote that letter to the city. We didn't get a response from either the appraiser or the city. And then latterly, I was retained by you and Darby Ducombe to both testify as to the overall design and construct of the study, which I think has some critical failures before we even get to individual assessments, and more than one, several failures. And then as part of that, I've also been asked to offer as examples of specific assessments, which I'm prepared to do. So,
Can you please turn back to Exhibit 2? And what is this document?
so this is Exhibit 2 is a document that I wrote to you, and this really basically is an update of my BOMA letter, essentially. There had been a few changes between the preliminary and the final assessment, although none that corrected some of the deficiencies I felt and I outlined in the BOMA letter. So, but basically, this letter outlines what I think is a critical failure in several areas of the special benefit study, such that I don't think it is authentically measures the special benefit associated with the project.
We would offer this as Exhibit 41.
So marked.
So, Mr. Gibbons, did you reach an ultimate conclusion about the final assessment or the methodology used?
Yeah, I sort of have several layers, if I could go through them. Basically, the first thing I think that's important to consider is the LID boundaries itself. This is more than 6,000 properties, and probably maybe even more, $56 billion of real estate. Just to get, that would be if the average King County home is like $600,000, that would be like 93,000 homes. So in terms of sort of how much real estate value this is, I think that's frankly overwhelming. To take basically an aesthetic, which is a proximity issue to an aesthetic, and then take that study and look at such a broad definition of property and such a massive amount of property value. Frankly, it's inconceivable that you could reliably do it, and it hasn't been done. Yeah. So that's the first thing, is just the actual LID boundary. Probably the second thing is there are various references to the project, but it's actually a little bit unclear exactly what the project is. It calls itself a park. I think it's really more of a linear landscaped boulevard. It includes a lot of design features which are associated with streetscapes already. And I think the definition of what it is important, because then the word park sort of takes on a meaning of its own and becomes substituted for other parks in other areas which actually are very different. So there is a lack of definition about what it actually is. Where is incrementally, where is the money spent in the park? If this is a proximity issue, where is the precise investment of dollars on a block-by-block basis? And how much of those dollars are being invested in design features that would be put in place anyway, if there was no park, to put it in a vernacular.
And I'm going to stop you there. What do you mean that would have been put in place anyway?
Well, one of the most fundamental flaws of the study is the definition of before condition, because the before condition is not in place. So the city's study measures the value of the property today without the before condition improvements. And you would be forgiven on several occasions, because it's happened to me, of looking at the LID after and looking at the LID before and getting them mixed up in terms of the way they look, because they have some very, very similar elements of the completion of Alaskan Way, street landscaping. So if the after Waterfront Park creates a lift in value, then surely the before improvements, which are very similar in scope and identical in location, not as much greenery, obviously, as we'll go through in a little bit, but where is the lift of current values associated with the before condition? Because they're not there. And so the study measures before values today, and then it measures after values after the special benefit. It forgets that the city would have to do a tremendous amount of work in the before case to get to that condition. That value is not measured. It's not included in the study, and therefore it is incorrectly included in the special benefit by definition. So that definition of before value is, and this actually goes right back to my request for these pictures, because at that time the pictures presented were of the property with the viaduct in place, not really the before condition. So I think that's a major error in the analysis. Is it?
Yeah, that was great. So are there other errors that you identified?
Yeah. The other thing is, and this is absolutely key, is I think we hear at least in my world, we hear the term special benefit a lot. And the term is run together, and I think it tends to lose a little bit of its meaning through overuse. Special is different from general benefit. And the literature and the LID manual and even Mr. McCauley's report emphasize the importance of not taking into account general benefits. And this is extremely problematic for this project, which almost by definition with 6,000 properties has an LID area that is very general in nature. So the distinction between special and general benefits is very important. If you did a search for the word special, if you did a search for the word general benefit in Mr. McCauley's report, you would not find that term. The only reference I could find of that term is basically lip service to needing to make the distinction, which is on page 26 of his report.
Yeah, and that is Exhibit 19. Sorry
Yes.
to interrupt.
Yeah.
Exhibit 19. Let's just turn to that right now. And again, you are on page 26?
Yes.
Okay. Under the heading definition and discussion of special benefit?
Yes.
Okay.
Yeah.
And so what language is it in here, do you think is sort of what you call the lip service that Mr. McCauley pays
Well,
to general benefits?
Absolutely. Here is where it's indicated is that the special benefit, this is the second paragraph, a special benefit is defined as a specific, measurable, and we'll return to the word measurable in a minute, increase in value of certain real property in excess of enhancement to the general area. So obviously the general area in this case would be downtown, So if an appraiser is required to measure special benefit, he's also required to measure the enhancement to the general area as a result of the project, because you can't measure the benefit without knowing how much of it is if you measure the benefit, you have to then decide how much is special, how much is general. And he has not done that in this report. There is no reference beyond, after this point, to the word general benefit. Let's see. The next thing that I would go to is the issue of measurable, that is also in this study. So Mr. Macaulay purports to be able to measure for the entirety of downtown a benefit, again, total benefit, not broken out between special and general, but he purports to measure a benefit of up to 4%, and in most cases it's 2 or 3% of value. With all due respect to his appraisal skills, you can't measure value to that increment for a property. If you took 2 MAI appraisers and had them appraise a downtown piece of real estate with identical information, the chances are they would have a judgment difference of at least 5%, maybe as much as 10%. And so already in the analysis, you have a standard of error of valuation, a standard of error that exceeds what you're trying to measure. So if you were to put this sort of in an academic world, if you're trying to find a 2 or 3% difference in something, but your measurement technique cannot resolve an error just for the data, how people behave as rational or non-rational beings, or simply the change, the ebb and flow of a market, if you can't resolve that error of less than 5%, you can't find a 4% difference. Can't be done. Special benefits have to be measurable. You know, they can't just be an immeasurable assignment, you know. And that goes to my next point. So how is this done in this study? How can he have measured something that I don't think is measurable? He didn't measure it. He assigned it. If you look at the study and you look at the manner in which it is undertaken, what has happened here is the properties have been assigned a special benefit. This is not a before and after appraisal. It's presented as that subsequently, but basically the after valuation is simply the addition of a benefit, the special benefit, supposedly measured, to the before value. There's actually no instance in the appraisal where they say, well, here are the after values, and let's see what the difference is with the before, and calculated the difference. So that's a major problem. You know, you can't simply assign a benefit because it becomes a self-fulfilling prophecy. It's not measured.
Can you tell how Mr. Macaulay determined which properties would receive a special benefit from the LID?
No. I mean, this really goes to the complexity of the issue. If you look at, let's take a high-rise piece of real estate like this one that we're in now. The value of that property is generated by a series of rolling leases. You know, what do people pay, and those leases kind of roll, and the building has an occupancy. You can't reliably measure the value of that property without knowing those details, not known by the appraiser. So basically, he's taking projected market, very generalized market information and applying it to a property. There's no way of knowing how accurately it is applied unless you know the intimate knowledge of that building. And then the second thing is, every building will have a different response. If you take a new building that has a 20-year Amazon lease, where the lease rate has already been negotiated and set, there's no way for that owner to then benefit from a new project in downtown because he can't charge the tenant more rent as it's set. And most high-rises have this problem. They have this rolling 10-year cycle of leases. So there are far more fundamental differences in the downtown area. Like the Russell Investment Center. This is just an idea of what type of real estate we're talking about. Russell Investment Center, 2003, $280 million property constructed, sold in 2008 for $115 million, and then sold again in 2012 for $480 million. Massive changes in value. Downtown real estate generally tends to swing by a matter of 10 or 20% between times of recession and non-recession. Again, these are not properties that you could reliably go in and say, well, that property increased by 2% or 3%. I don't think it can be done.
Who made the decision about which properties would receive a special benefit?
Well, that responsibility lies with Mr. McCauley. I don't know who set the LID boundaries. The appraisers who set the LID boundaries, not the municipality. The municipality can set it, but then it's the appraiser's responsibility to say, okay, I don't think these properties are benefited or these properties. I think targeting the whole of downtown is, quite frankly, creates a general impression of this is either a project for a general area that's so large, it's a general benefit. But we have to go back to the word special, and there's been a lot of distinction about what that term means. The one court case I probably like the best, it's on page 3 of my letter. It's the third paragraph. The most satisfactory distinction between general and special. A special benefits are those derived from the peculiar relation of the land in question. So to assign special benefit, and in the paragraph above, I've got standard definitions of special: better, greater, otherwise different from that which is usual, remarkable, noteworthy, singular, unusual, unique. These are all terms that apply to the term special. And so if you were going to try and do a study like this, you would look and see which land parcels have a unique or special association with the project. Like, are improvements going to be right on the sidewalk of the property? That would be something that may be different from other properties downtown. Does the property have a unique view of the park somehow? And that would tend to suggest that, then you should be differentiating between condos that face it versus those that don't. You would start to have to really get into the detail. What is the issue with this particular property and how it relates to this improvement? And in my opinion, for an aesthetic, once you get 2-3 blocks away from it, I think you're starting to challenge the notion of special relationship. I think it defies explanation as how you could be special once you get a few blocks away from it. And even if you were associated directly with it, you would have to have some unique relationship to the project that was different from other properties. So you could draw a distinction from the general benefit created versus something that's special to your property.
Do you have any authority for this idea that you assess general benefits when you're trying to calculate a special benefit?
Yep. It's in the LID manual, and we can go into that in a little bit. Jim Eaton is probably one of the most frequently used appraisers texts is called Commercial Appraisal and Litigation by Jim Eaton. He's a member of the Appraisal Institute. He wrote the federal standards for land acquisitions, which really gets into special benefit. And I've got his quote. It's the 2, 3, 4, the fifth quote down on page. Oh no, wait a minute. It's actually at the bottom of page 2.
And
You're
looking at-
referencing Exhibit 41?
Yes.
Sorry.
It should be noted that project enhancement may be composed of general benefits, special benefits, or a combination. Thus, it may be necessary to allocate the project enhancement between special and general and to consider only the special benefits in estimating the value of the property in the after situation. There's also the LID manual.
Yeah, and that is Exhibit 4 in that binder right next to you. It's already been admitted. What is the LID manual? Can you just tell me
Well, this
what
is
it
this is sort of, and actually, Mr. McCauley has contributed to this. This is a manual that helps guide both appraisers and attorneys into the formation of LIDs and some of the things that should be considered. So throughout this manual, basically asks the appraiser to consider general benefits as well as special benefits.
And before we get into the
Yep.
specifics, I see that Mr. McCauley is identified on page, the 5th page as a contributor, so he contributed to this particular
Yes.
version of it? Okay.
Yeah.
And what pages are you talking about that reference general versus specific benefits?
Start with page 58.
Okay.
Yeah, so here is, this is number 3. And it says, top of the page, consider general benefits as well as special benefits. And this is particularly noteworthy on the 4th line. Consideration may also be given to those construction costs related to meeting design standards, which may be general benefits. So this is particularly germane to this project because the before condition is required to meet design standards for streetscapes and improvements, and that should be part of the before condition. So that the extent to which the waterfront project is simply being undertaken to meet those design standards, that portion should have been X'd out, both in terms of cost as well as by the appraiser. So how much cost is associated with meeting design standards versus how much cost is related to the actual portion of the project for which you're going to take as, say, well, this is special and a special benefit.
I'm sorry, Mr. Gibbons, you you said something about numbers being X'd out. What do you mean by that?
What I mean is that if there are portions of the LID of the cost of putting the improvement in place are simply associated with doing street improvements that would have to be done anyway, then that's part of our before condition because that would have to be done anyway. It's messy in this particular case because the city hasn't done the before project. So we don't have an incremental accounting of what is special for the waterfront LID project on top of what they would have to spend anyway in putting in Lascombe Way and doing necessary street improvements. So that portion of the project should be X'd out, basically taken out. It's not a part of what's special to the neighborhood.
Any other references to special versus general benefits in the LID manual?
Yes, on page 65. Towards the bottom of the page, there's a question, what are special benefits, ? And again, special benefits refer to special as opposed to general benefits. And then it says, in other words, improvements which are substantially more intense to the property which is assessed than to the rest of the municipality. So it's substantially more intense. Again, the appraiser should draw out the distinction of how the improvement is peculiar or different for this particular property versus other properties. At the bottom of the page, it says the distinction between public improvements which are local in character as opposed to general is explained in another case. And this is City of Seattle versus Rogers. And this, again, this is very, on the third line of this, starting from the beginning, laws recognize a distinction between public improvements which benefit the entire community, in this case it would be downtown, and those local in their nature which benefit particular real property or limited areas. A property benefit is usually required to pay the expense of the latter, and just the latter, I would add. It says, a local improvement is a public improvement which, although it may incidentally benefit the public at large, is made primarily for the accommodation and convenience of the inhabitants of a particular locality, which is of such a nature as to confer a special benefit upon the real property, and here we go, adjoining or near the improvement. I mean, this issue of proximity and access to the improvement is critical. And again, when you look at the LID boundaries and you consider Seattle's hills that rise up from the waterfront, you question whether those boundaries are accurate if every property in that boundary is going to be assessed a special benefit.
Are there other provisions in the LID manual that you'd like to call our attention to?
I think that is it. Those are the
Okay.
three I pulled out.
So what would you normally assume an LID boundary to be for ascertaining a special benefit?
Well, you would, and again, this is, we're trying to take a sort of a statutory provision for helping a local government fund some infrastructure for typically something that is needed. And I'm not, well, I probably am saying a park isn't necessarily fall into that of an essential public service, but typically an LID is being used to fund roads, it's being used to fund sewer lines. So typically let's take a sewer line, that's probably one of the most common uses of an LID for a small municipality. The LID boundary becomes the service boundary for the thing. It's very well defined. It's very concrete. The improvement itself is very is obviously measured in terms of the difference between having sewer and not sewer, in terms of what you can do with a property. Here, these boundaries they extend a huge distance, and if you look at many of Mr. Macaulay's examples, and we should go through them, they extend well beyond where his own studies show that he can actually say there is a benefit. I think he's relying mostly on the Compton study for extending it as far as 12 blocks. In all his examples, I can't find a circumstance where there was a park improvement which extended for the entirety of downtown. Not one of his studies measure the entirety of downtown as a special benefit area.
And maybe it makes sense to look at some of those examples now. So the final study is Exhibit 19. And do you want to give us a page number for the studies?
Page, I started on, I looked at some of his waterfront park examples. Page 49 is the first.
Okay. And that's the discussion of the park in Portland, Oregon?
Yeah. Now, I'd have to say at the outset, the discussion on these studies, on these properties is interesting, but in my opinion, it does not rise to the level of empirical appraisal data sufficient to opine on a special benefit for a particular property. And if you read all these studies, it's enormously secondhand, very, very general. There's actually no, and in some respects, the appraiser's treatment of downtown Seattle is being undertaken in a similar fashion. Very little, no specific examples that in my mind would raise to the level of a measurable increase for a specific benefit. And let's just look at them. So on page 49, this is the Tom McCall Waterfront Park in Portland, Oregon. So the evidence starts on the third paragraph. Interviews have been conducted, we don't know by who, with area brokers knowledgeable about the residential, commercial, and office market in downtown Portland. The brokers were asked how, if at all, the waterfront park upgrades affected overall market rental rates and what general perceptions were held by the market. Generally, in terms of retail and office rents, due to the presence of heavily trafficked NATO Parkway, the consensus has been that the highest level of positive influence is seen within the immediate 1 to 2 block radius of the 3 new upgraded public pavilions. So that's the evidence, and this is we don't know who these brokers were. We don't know what they're talking about. We don't know what time frame they're talking about. We don't know what other factors have been involved in the area. We don't know how the economy relates to this.
Was this an LID project, do you know?
I don't believe any of these were LID projects. It's not noted, and I think it would be. And so they're extremely general. There's no detail. I don't think you could really take out of that study and say Seattle is going to get a 2 to 4% bump for this park. You just cannot. And in this particular case, 1 to 2 blocks. That would probably be the most germane aspect from here, is that this park is a 1 to 2 block influence. If we go, the next one is the Embarcadero Park, which is arguably the most similar in the sense that it was something that was subsequent to the taking down of the Embarcadero elevated freeway. Here's an omission. Here's a confession. I'm not sure that's the right word, but at the bottom of the page it says, and this would apply completely to Seattle. Due to the unique geographical and neighborhood characters of San Francisco, as well as the design of the interconnected parks, it is difficult to measure the direct impact on property values due to the project. Now, if that, looking at an example study and applying that to Seattle, that would mean if it's difficult to view for this kind of project, it's certainly difficult to view for Seattle. And again, does this indicate a 2 to 4% increase? It's nowhere in here. It says the CBD has many points of interest and features that attract. It also says that the park was put in after the freeway was demolished, very similar to ours, and much related to enhanced view amenity. Same for Seattle. These things are all mixed together. And then the largest sentence is greatest impact within 2 block radius. Again, this proximity issue, and then a comment. Brokers indicate a 10 to 20% increase in values adjacent to the enhanced portions of the park compared to similar properties a few blocks away. Again, there's no definition of what these properties are. There's no definition of what type of properties these are. Again, it's brokers talking. It's not appraisers. It's not someone actually measuring them according to an appraisal standard. Very, very generalized, anecdotal. Again, that's what I say, anecdotal information, not appraisal evidence. The last one I sort of pulled up was the False Creek conceptual plan of Stanley Park, which was 80 acres, and 60 acres was set aside for public-private development. So in this case, this also revolved around a public-private project to encourage new development, which would have been obviously a positive influence, and 20 acres of parkland. And this time it quotes an appraisal company, Collingwood Appraisal Limited, provided data on 322 sales of apartments, and this is now 6 blocks, and paired analysis suggests a premium of 12 to 16% within a 6-block radius. Again, we don't have the study. We don't know precisely what they were measuring. If they were measuring view amenity, that has to be taken out, and that is noted in the second paragraph by Mr. Macaulay on page 56. The pad sales analysis is influenced by view amenities. I would say that's an understatement. And he merely says, oh, Seattle would be less than that. Again, there's no definition, there's no way of ascertaining exactly how Seattle would behave, or what part is general, or what part is special. Again, 6-block radius would suggest at 6 blocks, 0, and at the front line, the 12 to 16%. So again, not similar to downtown's 12 blocks, and in my opinion, not evidence sufficient to support the special benefit applied.
Did any of these other properties studied by Mr. Macaulay, are they similar in scope? Are we talking about a landscape boulevard?
Yeah, I felt they were all much more larger areas of greenery and landscape. Again, there's not a lot. Mr. Macaulay doesn't provide any side-by-side comparison. How much park area are we actually what are we calling a park? Is the boulevard a park? Obviously, a sidewalk's not a park. So there's no side-by-side analysis, but just looking at some of the pictures, the impression is that they are more park-like than Waterfront Seattle is park-like, which is, again, really an enhanced boulevard.
You were talking about proximity. Is there ever a case in which proximity to an improvement is not a special benefit?
Yeah, this is, and actually there was a court case about this in another part of the country, but we were hired by the Department of Justice to look at the East Lake Sammamish Trail. That's basically that's a conversion of a rail to a linear park. And what we found is that there was a general benefit to the area, because proximity, to basically a transportation corridor for residents, but actual damages for those properties actually on the park because of interference with private property ownership issues. So absolutely, you might have the only place I've seen that in downtown here with this park is probably Overlook Walk in relation to the Waterfront Landings condominium, where Overlook Walk basically shows its backside. I like to think that's a real estate term. Backside to the Waterfront Landing, and then the Waterfront Seattle project actually includes bigger, taller trees on the streetscape in front of the condominium, so that they'll actually get view blockages, and they'll be behind Overlook Walk. There are probably damages for that project, not special benefits in that particular case.
But they have been determined to have special benefits, right?
Yes, yeah,
Okay.
and layered it the same way with this sort of broad brush 3% brush.
Okay. So we've talked about a number of flaws in the final assessments methodology. Any others that you'd like to flag?
Well, I felt like probably the other issue is how the assessment is created. So Mr. McCauley has assessed, has taken before values and applied 1, 2, 3, 4%. Most appear to be in the range of 1 to 3% increases, and he's treated. He on page. See if I can find it here. Yeah, on page 60 of his report, he has really, I want to say it's really lip service to proportionality, because a property, he's really appraised, though, generally speaking, he's applied these percentages with very little variation to land and improvements together. The problem with that is a proximity issue associated with a park, or if it was actually a sewer or something like that, really relates to the land value. It's the land that becomes more valuable. The improvements don't change, as an example, you could take Waterfront Place down on the waterfront, that next to the viaduct, they built their parking garage on those lower levels. Well, that improvement really can't benefit from those lower levels having a view with the viaduct down. So the improvement isn't changed, but the land value is potentially changed. However, by not targeting land value for all properties, he created some huge proportionality problems. And I mentioned this in my letter, and we'll then go to a couple in Pioneer Square. But I've got examples on page 6 of my letter. The first example is actually probably the most interesting, because this was a issue I noticed in the preliminary study where, and if you look at my BOMA letter, I pulled it out in the preliminary study, the 2 and U site, which is a high-rise office site opposite 1201 3rd, it's actually in the way of 1201 3rd. In the preliminary study, this was treated as a parcel of land and received an assessment of $622. Well, at that time, there was a office building under construction on it. So by the time the final assessment comes around, the office building is now at least topped out and more substantially there. Suddenly, the assessment climbs from $622 to over $4 million. Well, the improvement portion of it has not changed. The cost of the improvements is the same in both cases. It's just a matter of timing. And yet, they ended up with, because they happened to get the timing slightly wrong, they ended up with a $4 million, an increase of $3.4 million between the preliminary and the special benefit. If Mr. McCauley had been properly assessing just land value, he wouldn't have had that issue. The problem remains in the second example with 1100 Alaskan, that's a parking lot down on the waterfront, and 50 University, which is a Cyrene apartment. Well, 1100 Alaskan is going to have a 257-unit apartment building on it, complete by the same time that the waterfront project is complete. However, the assessment on that will be just $5,000 a unit, whereas on Cyrene Apartments, it's $18,000 a unit. Again, lack of proportionality, totally inequitable assessments, because Mr. McCauley has failed to address the fact that this relates to land value increases, not total property value increases.
And this is a problem that he could have fixed?
Yeah, you would look at rising land values. You don't look at the total package of the property. You certainly have to be aware of what's on the property to see the extent to which they're able to use that higher land value. But basically, it's the higher value of the land distributed through the improvement. The improvements themselves do not gain value.
And why is it important to distinguish between vacant land and improved property for these sorts of assessments?
It's because if you don't, you get a series of inequitable treatment. I mean, consider the irony of it. If the project is, and this is not a theoretical academic issue. Down on the waterfront, ever since the viaduct got taken down, we've seen a lot of proposals. There's the 1100 Alaskan parking lot. There's a commuter building, which has just got purchased and is going to be new office building. There's the Citizen M hotel site, which just got purchased. And then also the Weston and Polson buildings. All these properties have much greater potential than their current use. And yet, and they're on the front line, so to speak, and yet they are going to receive assessments at the lower end of the range because Mr. McCauley has treated them as basically low-end buildings or land sites versus high-rise real estate. And we can look at the Embassy Suites and show that in detail of what an impact. And again, the irony is properties further away have received a higher assessment just because they happen to be complete now versus ones on the waterfront that are not.
How does the fact that there are lots of different kinds of properties in downtown impact, or should it be taken into account in the analysis?
Yeah. This goes back to really my first comment of how overwhelming this is. You have different hotels targeting different audiences. Hotels up by the convention center targeting business, convention, traveling public. Very different from the Courtyard Marriott down on the waterfront. The one by the stadium catering to sports events and exhibitions. All these properties have different market elements, and same with the office buildings. The time travel for lunch, how far away they are from the waterfront area. There are so many individual complexities and differences between these properties. I don't think a mass appraisal study, again, cannot create an authentic measurement of special benefit for these types of properties.
So before we move on to the specific properties at issue here, do you want to just summarize like your top 5 criticisms of the report?
Yeah. The 3 words I really think that embody this study: remote, speculative, and imaginary. Remote, speculative, and imaginary. And if you go through this special benefits report, it's imaginary in terms of its extent of influence, the amount. You can't measure 2 or 3%. You have to imagine it. You can't measure it. It's entirely speculative. There is no sound empirical evidence presented in the study which supports the incremental assessments made. And it's also, for most properties, it's remote in time and space. The actual won't be complete for several years. There's a construction period prior to it being complete. And most properties downtown are remotely located from the improvements. And so basically, those are the 3 words that I kind of would like to leave you with on the overall study. And then no assessment of general benefits, benefits are not measured, they're assigns. The improvements are not properly quantified in terms of the actual cost for incremental blocks in association with particular properties. There's no measurement of the before value changes that would happen anyway, what influence. And the before project is so similar in many respects to the after project. Not measuring its value increment and deducting it is a major omission of the study. There's a huge inequitability relationship by the manner of the assessment, not looking at land and building in appropriate proportions. And then finally, the property type, the area, does not lend itself to this kind of discrete measurement of a 2 to 4% or half to 4% measurement. It's the property type is too complex. You have to know too much about each property to really properly appraise it. And if you have a standard of error that exceeds what you're trying to find, by definition, you cannot measure it.
Do you think that this study meets the standards necessary for appraisals?
I haven't really evaluated it in that fashion. I haven't looked at whether it's a USPAP standard. Certainly from the standpoint of just supporting the benefits assessed, which is a judgment-related issue, not really a standards issue, it's judgment, it does not do that.
Let's turn now to the specific properties at issue here today. And I think we're going to start with the addenda to the report, which I think we've marked as a separate. It's actually, it's going to be behind tab 19, which I think is in that binder. Yeah. And this is Exhibit 31. And while we're getting to exhibits, let's turn to the last. You can also have that binder in front of you that has Exhibit 57 in it.
Yep.
These are the sort of blow-ups of this that.
Okay.
All right. And are you familiar with Exhibit 31, which is the addenda?
Yes, I am, yeah.
Can you just tell us generally what sorts of information is included in the addenda?
Yeah, this was the first time I'd seen this because it wasn't in the preliminary study, the addenda. And so this actually goes through in fairly incremental fashion, although again, it's difficult to decide, looking at the different pictures, which are artist renderings, so you have no idea how much license has been taken in terms of exhibiting certain differences between the reports. But it's the first time we've actually seen at least what the city believes is going to be the difference. But these materials weren't available to Mr. McCauley when he did the preliminary study, but presumably they were available when he did the final one.
Okay. So let's turn first to page 12 of the PDF, which is somehow an unnumbered page in this, but contains the, so it's the 12th and 13th page in this document.
Okay. Yeah.
Which contains sort of the streetscape. And again, it's the Waterfront Seattle program is page 12, and then Waterfront Seattle program, no LID, is page 13. So that means the second page is the before, right?
Yes, that's
before.
correct, yeah.
Okay, before and after. And how did you use these documents to evaluate?
So,
the-
counsel, I'm not with you on what pages
Okay,
you just
I'm
worked
sorry.
with. I'm
Okay.
just getting this document for the first time, so you want to
That's
walk me
fine.
through it. If you want me to follow,
the
you'll
page
have
after
to
A8?
get me to it.
Is it the page after A8? It is the page after A8. Sorry. So, and again, so the first page is the after with the LID. And the second page is the before picture that reflects improvements that would be done, would be made after the viaduct comes down.
Yeah, yes, right.
Okay.
And these were the two exhibits that, a couple of times I looked at and I thought, oh, that's the LID, no, wait a minute, that's before LID. Very difficult when it's not in place to evaluate what kind of lift that would have provided.
Okay. And, let's see. Do you want to go next
Yeah.
to the Exhibit 57, which is, I think, a document you created from those drawings?
Yeah, so. Yeah, so the first one, this was, I think it was page 27.
So let's,
Yeah, how do you want to do this?
can we start with these? This is Exhibit 57.
Yes, yeah,
Okay.
yeah.
So that should be in the other binder.
Oh, okay.
Yep.
Great.
Again, hearing examiner exhibit number?
57? Oh, I'm sorry.
I think it's been
Yes, and it
admitted.
hasn't been admitted yet. And I will offer it now.
All right, so we're pulling out your exhibit 57?
Yep.
That would be 42.
And Mr. Gibbons, can you just tell us what these documents are?
Yeah, I wanted to look at just a couple of projects sort of specifically, and just really that I think illustrate the complexity of it. So the first one was 255 South King Street. This is the Embassy Suites. It has 282 rooms.
And so when you have the first two pages of Exhibit 57 that compare the without the lid and with the lid for that property, right?
Exactly,
Okay.
yeah.
If we could just make sure we're referencing the once they've gotten an actual number.
Oh, I'm
not to-
sorry.
Not to get, it'll
Exhibit
confuse the record
42.
if we keep flipping between the two.
Sorry, Exhibit
That's all right.
42.
Exhibit 42.
No,
It's
sorry.
under tab
it-
57.
You're good. Stay with
Okay,
tab 57.
good. Okay, so.
Qualify it with our 57 or something
Yeah,
like
yeah.
that, so he can
Sorry about that.
differentiate.
Oh, okay,
but
I
For
got
the
it.
record, it's
So-
exhibit 42.
Yep.
Right, so our exhibit 57, you'll see I've sort of highlighted two portions of that previous exhibit that we talked about, the with and without. And this 255 South King Street is actually in the lower left-hand corner of the property. It's next to King Street Station. So it's that block, it's half of that block in the lower left-hand corner.
The one that's half cut off in this picture?
Yes, the one
Okay.
that's half cut off. And if you turn the page and look at it with and without the LID, you'll notice that there's actually no waterfront improvements, no improvements in front of the building at all.
Because they stop at Second Avenue?
They stop at Second Avenue. And in actual fact, I think they actually stop at First Avenue. I think this chart is inaccurate. When I read the description of what actually happens on King Street, there are 2 new street trees. There are some planting strips and diverse landscaping on the north side of the street, but only east and west of First Avenue, and then some curb treatment mid-block, north side of King, and then again a new curb bulb at First Avenue and South King Street. So there's actually, within a block of 255 King Street, there's actually no waterfront improvements at all. That property has no peculiar or special association with any improvements that are going to be completed. The property received an assessment of $2,358,000. That's about $8,400 a room, and it doesn't appear there's even that much investment on King Street, and so I completely question the judgment involved in saying that property is going to get a lift from these improvements that is special related to this project.
And just
Yeah.
a question about the narrative that you have under the with lid. You said the narrative is different from the picture in the addenda. Where would I find the narrative describing the actual improvements that are being made?
That's on the bottom of, it's Exhibit 57 is the second page of Exhibit 57.
But where did that
Oh.
where did that come from? Did it come from the addenda or from the final study?
I think I pulled that from the addenda.
Okay.
Yeah.
Okay, great.
And there's actually a picture of it, of these two new street trees. But again, like the actual landscaped improvements, some of which are in front of Martin Daniels' property, which I think he actually put those improvements in there as part of his development. So I think that's inaccurate, and in any event, there is no special association with that property with the waterfront. The second one I wanted to bring your attention to was the Courtyard Marriott. It's at 612 2nd Avenue. It's in the old Alaska building. And so this property, there's 236 rooms. This property was assessed $2,566,000. In this particular case, the closest way to get to the waterfront would be to walk down Second and then take a left on Columbia, which 4 or 5 blocks. There are no improvements on Columbia. Columbia is already improved. There's going to be no waterfront improvements on Columbia. That property, with a $2.5 million assessment, has no special features at all related to the waterfront project.
And Mr. Gibbons, if I could turn you back to our Exhibit 57, which
Yeah.
has been marked as Exhibit 42. I think it's the second and third pages of this document that relate to the Courtyard Marriott. Can you describe for me where on the map the Courtyard Marriott is located?
Yes, actually, the Courtyard Marriott, actually, you can't, it's off the map.
Okay.
So I went as far south as the map shows. The map
Okay.
shows actually cuts off Seattle at 2nd Street, this map.
Okay.
They don't actually show the blocks. So it's, it would be, the Courtyard Marriott is about where the CO of Columbia is
Got it.
without lid. It's
Okay.
approximately there across the street on 2nd. Now, in relation to the Courtyard Marriott's assessment, I'd like to draw your attention, this is same exhibit, Columbia without LID. There is a triangular parking lot on the corner of Yesla and Alaskan. So it's in the northwest, in the upper right quadrant of that. Do you see that parking lot right there? It's on Western Avenue and Yesla.
Oh, yes.
Yeah. So that property, this is an example of inequitable treatment. The Courtyard Marriott has 236 rooms. This triangular property has already received permits for construction of a Citizen M Hotel, 10 stories. It's going to be 216 rooms. It's actually mentioned in Mr. McCauley's report, although an earlier rendition when it was 232 rooms. Mr. McCauley assessed this property of $135,000. So this property will have a Citizen M hotel on it with 260 rooms by the time the Waterfront LID is complete. It's right at the corner of the Esler and Alaskan, $135,000 assessment, whereas the Courtyard Marriott, which is already complete, $2.6 million, which is $10,873 a room. Citizen M Hotel, $625 a room. So massively disproportionate in terms of the assessment between those two properties, which have basically will accommodate very, very similar improvements in the time frame that the Waterfront Seattle is complete. The other property.
So before we get too much further into
Yeah.
the properties, if I could ask, maybe is there some type of, when we did the intro, it was all about argument. There wasn't any presentation on where these properties are, which ones are at issue.
Yeah.
I'm wondering if we could do just a basic overview.
Yes.
Is there a single map that does have them on it? You've referenced one that's not on the map, so.
Yes.
It might be clear for me to follow along with specific streets, specific
Yeah.
parking lots,
Yep.
if I know
Yeah.
exactly where the property
All right.
is, where the
All right.
trees are. You've gotten to a level of detail before we got to the overview of
Yes. Yeah.
where we're talking about.
Okay.
You're establishing a good record for your case, but if you want me to follow along, it'd be helpful if we took that step back.
So Exhibit 3,
Yeah, Exhibit 3.
at page 18. Has the very high-level overview of what properties we're talking about, but we will be putting on witnesses to discuss each of the properties.
Okay.
Yep.
Let me ask you, can we go by case number? If you can give me each address for the properties.
Yes. Yes. Okay. 255 South King Street is case number 336.
Okay, that's 255
South King Street, sorry.
South King Street.
Mhm.
And do you have any, are you referencing that property with any common name? Like
It's the Embassy Suites.
337?
336. 337 is the Courtyard Marriott.
And the address?
618 Second.
Okay. And 339?
1000 First Avenue South. And that is sort of what we call that property. But it is two parcels, and so it is 339 and 340.
Okay. And no common name?
The
Just the
Palmer
address.
Building. and
I'm sorry?
Palmer Building.
Okay. I just want to make sure I'm following your vocabulary when you reference it for your argument. And then we have 342.
Which is 1016 First Avenue South. Where are we going?
What do you call 1016?
Olympic Reprographic Building.
Olympic Reprographic.
And I think no, that's just an address. That's all of them, right? Okay.
Yes, yep.
Okay, so those will be all the ones we're covering over the next couple of days, and, all right,
Yes.
thank you. And
1016 is
the-
sometimes addressed as 1014, which might be.
That's confusing, okay. And the only overview that has all of these on them is this page 18, Exhibit 3.
think so.
I think that's right at this point.
Okay.
If it would be helpful, we can maybe come up with something. And we do intend to introduce some photos of them to sort of orient. I know for me, it's helpful to see what they look like on the outside to figure out what we're talking about.
And now with that, at least I can keep up with you. In different cases, sometimes individuals are referring to their properties by address, by name, and by case number, and I've got all of that, so you can
Great.
just go with your own flow.
So just before we break, can we talk about the properties located at First Avenue South? The 1,000 and 116, I think they're shown on Exhibit 42, which is under tab 57, the last two pages that say railroad without lid and railroad with lid.
Yeah, so both these properties,
They're
they,
off the map.
yeah, they're,
Sorry, I didn't hear what you said. Sorry. They're off the map.
yeah, both these properties aren't on the city's map, you know, showing the waterfront LID improvements, with and without. The closest you get to it is railroad. This would be how somebody in that property would access the waterfront. They go down Railroad Avenue. So I looked at the improvements on Railroad, see if there's any sort of special association there. If
And are
look
you
at-
able to indicate which is Railroad Avenue? Because
Yeah, it's
honestly, in
the-
these, the road names don't show up.
Oh,
so.
it's the, it's the lost Exhibit 57.
Yeah, I've got the map, but the road
Oh,
names are all blurry,
it's,
so.
yeah, sorry, it's really small there.
I don't know
It's-
Railroad Road.
It's the one at the top, right south of what says the Seattle Tunnel Portal. So that's Railroad, you can just see it in red there. Railroad, and then and Stadium Plaza, and it runs along the top there in red. And that's Railroad Avenue. Is that?
Basically been squared off using the,
Yeah, it's
Yeah.
the only portion, Railroad Avenue is highlighted in red on the exhibit. And that's the link between First Avenue South, this location, and the waterfront. And you'll notice that with and without the LID are identical. And so there's no, again, for these properties that purportedly have a special benefit assessment of 0.65%, 0.77%. I mean, really, again, imaginary assessments. They're not proximate to the waterfront park, and the closest proximity is an improvement, a street that will have the same improvement in the before as well as in the after.
all right. I think those are all the questions that I have. I might have that's where I am right now. So I don't know if you're interested in questioning him after lunch, or whether that you're gonna wait. I know his deposition has been
So
calendared.
you don't have any further questions?
I don't.
For Mr. Gibbons? Okay.
Yeah, our intent would be to cross-examine Mr. Gibbons today, notwithstanding the fact that a deposition has also been scheduled.
Okay.
Okay, we're going to do that after lunch. We can go a minute early, and we'll come back at then 1:15. Thank you. And we return to the record with Mr. Gibbons on cross.
Good afternoon, Mr. Gibbons.
Good afternoon.
You own property in the local improvement district,
I do, yes.
and you've submitted an objection to the lid assessment.
I have, yes.
Earlier today, we learned a little bit about your background. I was wondering, does your practice involve providing expert testimony?
It does, yes.
And what portion of your practice is dedicated to providing expert testimony?
Very small part. Most of our work is for government assignments, and then we have I probably testify maybe once in a year, perhaps.
Okay. And are you working on an hourly basis for this matter?
I am, yes.
Could you tell me what the hourly rate is?
Yes, it's 360.
And this morning you mentioned performing a feasibility study for a potential parking garage in Bainbridge Island.
Yes,
And you mentioned that that was a feasibility study for a potential local improvement district there.
that's right, yes.
And did you issue a special benefit study in that case?
I did issue a report that provided my findings on whether it was worth setting up the LID and doing the final assessment, yes.
So the feasibility study was the only study you issued for that Bainbridge Island case?
Yes.
Aside from the Bainbridge Island case, have you ever prepared a special benefit study for a local improvement district?
No, I have not.
And you also mentioned this morning that you had experience evaluating special benefits in the condemnation context. Is evaluating special benefits in a condemnation case different than evaluating special benefits in a local improvement district context?
Well, it's different in the sense that typically a local improvement district is formed on behalf of property owners by a municipality, and therefore it's typically a different process by which you get to the calculation of benefits and damages. But when you get to the point of actually assigning either special benefit or damage to a property associated with a public improvement, the appraisal procedure related to that is essentially the same. In other words, you follow the same directive in terms of excluding general benefits, only assessing special benefits. And of course, there may also be damages, and that's something that an LID study should also consider.
So in the condemnation context, you're evaluating what the land should be valued at after it has been taken by the government, is that correct?
Actually, what it is that you would have a partial take of a property, say for a street widening case, that a property might be a portion of a property might be taken, and the remainder property is then judged to either be benefited, neutral, or damaged by that public improvement.
Okay. And does your practice also include providing appraisals for properties?
Yes.
Have you ever been retained to perform a mass appraisal?
Yes.
How many times would you say you've performed mass appraisals?
I'm the assessor for the Swinomish tribe, so I perform a mass appraisal for approximately 1,000 properties once a year. For tribes now have their own taxing districts after a recent court decision, and so they now have become the assessors for property located on the reservation, and I do that for the Swinomish tribe.
And the types of property involved in that assessment, is that mostly residential?
Mostly residential. There is a couple of commercial properties. There's a sort of a resort property involved. There's some industrial property. There's a commercial marina involved. So, but mostly it's residential homes.
And do you know off the top of your head how many parcels are involved?
It's over 1,000.
Less than 2,000, you'd say?
It is less than 2,000,
Less than 2,000,
yes.
okay. Is that the only experience you have in performing mass appraisals?
I'm thinking there's another perhaps, but it doesn't come to mind.
So I'd like to turn to the letter that you wrote in 2018, which is Exhibit 40 of the court's exhibits.
Okay.
Do you recall when you were retained to provide that review?
Well, obviously it was prior to May of 2018 when I wrote it. It was after having been attended several meetings. So I don't know how many months prior, but it was several months prior that I was retained by BOMA.
And do you recall about how much time you spent preparing this letter?
I don't, no.
Can you think of an estimate? Was it more than 10 hours?
Oh, well more than 10 hours. I mean, I attended 3 or 4 meetings. I read the entire study, so I keep track of all my hours. So, but yeah, it was more than 10 hours.
Would it be less than 50 hours?
I'm guessing, so
Okay.
I don't know.
Okay, thank
Probably
you.
less than 50.
And when you were retained to produce this letter in 2018, what was the scope of your engagement?
I think I was asked to provide a high-level document analyzing the conclusions of the special benefit study and providing my opinions on the degree to which it supported the assessments made.
And in 2018, those assessments were still in the preliminary stage, is that right?
It was. This was related to the preliminary assessment study, yes.
In the first paragraph of your letter, second sentence, it says, "The letter is intended as a consultation and not as an appraisal review." Appraisal reviews are governed by specific standards, is that right?
Well, it's the term appraisal review is a term of art for the appraisal profession. So if you were going to do an appraisal review, you would specifically look at elements of the appraisal, in my opinion, related to particular property assessments, and I wasn't doing that.
So the standards that we're talking about for appraisal reviews, those are set by the uniform standards of professional appraisal practice, is that right?
Well, actually, everything an appraiser does related to value is set by standards in that document.
And were there specific standards that you were following when you created this letter?
Well, USPAP requires you to be, sort of a standard sort of litany of things of being diligent, people understanding, your peer group understanding what you're doing, et cetera. And so this absolutely complies with USPAP for that. But to do an appraisal review would mean I would be reviewing 6,000 appraisals, individual appraisals that Mr. McCauley had done on each property, and I didn't do that.
So in writing the letter, what did you review?
Well, I reviewed the study. I looked at. I went to several meetings where the city elaborated on the kind of improvements that they would fund, the types of improvements, and there was a lot of discussion about operational issues, as the city's had some issues with operating their parks, and how that would be a part of this. And so it was a forum, and so I heard those questions, got the answers back. I specifically was interested in the appraisal portion of it, how the assessment was arrived at, and that's when I got into the images of the park and what's it going to look like. So now I've forgotten what you asked.
I was asking what information or data or materials you reviewed to prepare your 2018 letter.
Well, all we really had was the preliminary assessment roll from the city, and then also at the end of each of those meetings, they would, there were sort of promises, we'll produce this, there were various PowerPoint presentations sometimes, and those documents were occasionally provided in email to people that were present, and I would get those emails as well, and so I reviewed that material as well.
So let's turn now to your January 30th, 2020 letter, which is the Hearing Examiner's Exhibit 41. When were you retained to prepare this letter?
I'm not precisely sure, sometime in 2019, where I was contacted by Mr. Com and met her at her office, and then we went through basically my old letter, and this was prior to the receipt of the final benefits study. So when I was originally retained, we still only had the preliminary study done, and then finally the final study came through, and so I started reviewing that report immediately upon receipt, and that was actually pretty recently.
And you said earlier today that this 2020 letter was an update of the BOMA letter that we just looked at. Is that right?
Well, yes, I essentially was asked to, basically the same general scope, but now let's look at the new study and see what the kind of issues are in that study, and if some of the problems we identified previously have been corrected, essentially.
And so what documents or information did you review in preparing the 2020 letter?
I read the final study from Mr. McCauley. There was also a large addendum attached to that, and I reviewed that. In addition, my clients had been preparing various documents that were trying to basically get down to a granular level as to what improvements were actually provided in the park that were different. I don't think anybody had done that. Certainly the city hadn't done that. Or Mr. McCauley's study, it wasn't called out. So I reviewed those materials as well, related to sort of some of the incremental improvements and differences. And that work's been ongoing. I don't really get into any of that in my letter, but it's just, I guess, further provides a deeper understanding of the level of sort of generalness associated with the final non-specific analysis associated with final study. That none of that information was in the final study.
So these documents, were they created by counsel or by the client? Do you know?
They were created by counsel, just going through it, and I think they also have. There's a couple of planners, I think, involved as well, but I haven't seen that documentation yet.
And these council-created documents, is it fair to say that you relied on those in preparing your 2020 letter?
Actually, no. They were, essentially, most of them were provided later. They sort of confirm, I guess, they confirmed, in my mind, the generality of the study and the lack of specificity in the final special benefit study related to descriptions of these improvements. And somebody had gone through it more granularly and incrementally than I had. So I reviewed those documents, and it basically conformed with my understanding of having read the final LID study as to how they were not addressed in that kind of granular fashion.
So before you had listed these council-created documents among the documents you reviewed to prepare your letter. Is it my understanding that you didn't review them before you prepared the letter, or?
Some were being, I think, produced contemporaneously, but certainly others have been produced afterwards. But I don't reference them in this document.
Were your opinions influenced by those documents?
No, they generally, everything I've seen so far has generally confirmed my understanding of the nature of the special benefit study in terms of its lack of description and precision in defining exactly what is part of the LID, which has been something that I've had an issue with right from the beginning.
And your 2020 letter contains the exact same statement about it being intended as a consultation and not as an appraisal review, right?
Exactly, yes.
So you have testified that you reviewed the ABS final benefits study, and that study was prepared in accordance with Standard 6 of the Uniform Standards of Appraisal Practice, correct?
Should have been, yes.
And those standards relate to mass appraisals.
I believe so.
Does your letter state an opinion regarding whether the ABS final benefit study complies with those standards?
I didn't evaluate it for compliance with USPAP.
Earlier today, I think I heard you describe your conclusions about the ABS final benefit study as a difference in judgment. Is that fair to say?
I think it's well, that's a pretty big umbrella. I think it's the appraiser's judgment that finally relates to the application of special benefit, so yes.
Is it fair to say that the valuation of property involves judgment calls?
It does. It involves a lot more than that. It involves evidence, but upon which you make judgment calls.
So I want to look a little closer at some of the portions of your 2020 letter. Turning to page 3. About halfway down the page, you have a discussion about the special benefit definition and distinction from general benefits. You concluded here that ABS did not distinguish between general benefits and specific benefits in its valuation of the properties, correct?
They didn't, no.
And that conclusion assumes that ABS's calculation didn't actually take into account general benefits, correct?
No, they did not distinguish between the two. They measured total benefit and attributed it all to special. They did not distinguish between what component of it was general and what component would be special.
So you didn't see somewhere in the report where they bracketed out general versus specific benefits?
They measured the total benefit that they felt was attributable to the project and called it all special. They did not take the time and trouble to evaluate what portion of it was general.
And what are you basing that conclusion on?
because their study should have addressed the issue, and it didn't do it.
So next I want to look at page 6 of your letter. Now, here you're providing a comparison of vacant land and improved land and how they've been assessed under the special benefit study. Is that right?
Yes.
Would you agree that measuring the special benefit requires an appraiser to look at the fair market value of property
Yes.
in both the before and the after condition?
Yes.
And when valuing the property in the before condition, the appraiser determines the fair market value at the time of the valuation, correct?
Well, yes. I mean, it often is of a specific date, but in this case, yeah, they picked a date of November, I think, 2019.
And so when you're, as an appraiser, when you're determining the fair market value of a property and you have a specific valuation date that you set in your appraisal report,
Yeah.
the value of that property is as of that date, not at some future date. Is that right?
That's correct, yes.
So you also conclude in your letter that ABS did not measure the difference in value. Is that right?
That's correct.
Has the difference in value approach that you talk about in your letter been used in other local improvement districts?
That I've used here, that I've referenced here. Yeah, a classic example would be sewer LID, where you actually look at the value of property with sewer as opposed to the value of property without sewer, and you compare the two, and then you can calculate how much rise in value is associated with the addition of sewer.
So earlier today, you mentioned the importance of the description of the before and after conditions when performing a study. And you stated that the ABS study did not include the completion of the Alaskan Way improvements. Is that right?
They can't have. The valuation date of November, they're not in place. So there's no place in the report. Like I said, there's lip service to it in terms of charts showing before and after, but there's no actual placement in the report where they address the value change that would result from a November 2019 value to a value with the before improvements in place. There is nowhere in their report that they address that change. You know, they don't even indicate that it has no change, which would be unusual because the improvements are very similar to the Waterfront LID improvements. So they miss that step. They do not address any value increment associated with the before, the completion of the before condition. We have sort of a unique problem here in that the before condition is not in place. So we do not have values that represent the before condition, and therefore, if the before condition is assumed to be different, it's the appraiser's task to then change those values to reflect what that before condition would be, and he has not done that.
I'd like you to, do you have a copy of the ABS report?
Just certain pages that I pulled out.
Do you have the
It's tab
summary?
18.
Oh, thank you. This is
Exhibit 19.
Exhibit 19 of the hearing examiner's record.
So it's under the 18 tab.
Okay, I have it.
So I'd like you to turn to page 3. Oh, I believe you have the addendum there.
Is there another 19?
I think there's a, it
Oh,
might be right before.
18, or our tab 17.
There you go, that's great.
Okay.
Okay, so page 3, please.
Yep.
So in the final paragraph, second sentence, the ABS study states, a primary assumption of this study is that in the before, without lid scenario, the Alaskan Way viaduct has been removed and Alaskan Way is rebuilt to WashDOT standards at street level. Is that right?
That's what it says, but that's not what it does.
So your conclusion is based on the assumption that ABS didn't actually assess the properties in this before condition?
No, they didn't. They used a November 2019 value, and there's no adjustment or description or analysis or anything of the changes of market data that would occur for assigning values on account of the completion of this project. There's no analysis of the cost of completing that project and how it might change values. Nothing. It's words on a page, but it was not done.
And just to clarify for the record, could you turn to the front page of that study? Oh. And do you see the date evaluation there?
October 1st, 2019. Thank you.
Thank you. So let's turn back to your 2020 letter, please. Exhibit 41. And page 4. So about halfway down the page, you address parking.
Yes.
And you say that to properly measure the impact of the waterfront project, parking losses need to be considered, correct?
Yes.
And you acknowledge here that they were considered in the ABS study, right?
There's words on a page, like I said, related to the parking, but there's no, parking's probably one of the most tangible impacts on value of a retail property. And all this parking is in front of the retail piers. So the analysis starts out by saying in the feasibility, this loss will be documented as part of the more detailed special benefit proportion assessment study. And then in the final study, it's really not documented. It took some searching to find out how many stalls are actually lost. Mr. McCauley doesn't go in what the value of a stall might be to a retailer and how that could be a negative aspect of the project. None of these issues are addressed. All it said is, there's a vague reference to this being taken into account, but there's absolutely no place where it's taken into account. There's no description of how it's taken into account. There's no computation of damages associated with lost parking and then benefit associated with what is put in place. But like I said, putting words on the page doesn't suggest that it's being actually taken care of in the study.
So is your conclusion that ABS didn't provide enough discussion about the losses related to parking?
Well, all I have is what their study is, and their study should be comprehensive in terms of its evidence related to the special benefit. I assume if Mr. McCauley has comprehensive evidence related to how he addressed loss of parking, it would be in the study. So that's my assumption. If he has it somewhere else, then I would ask why isn't it in the study?
So on the next page, page 5, you also discuss timing, and you say that there is also no value discussion pertaining to timing.
Yes.
The ABS studies after condition assumed that the lid improvements were constructed as of the date of the valuation, which was October 1, 2019, right?
Yeah.
If the study is assessing the special benefits based on the assumption that the before and after condition occurs at the same time, why would timing be a variable that needs to be considered?
Because typically that assumption, which is usually considered reasonable in the case of a street project or a sewer assessment where you might be looking at a year of construction, that's typically a reasonable a shortcut on the part of an appraiser. We don't want to have to deal with inflation, and therefore we're going to look at it as a time-specific with and without on a particular day. And that's fairly routine. Condemnation is the same way. However, if there's a situation where the special benefit is actually not delivered in a reasonably foreseeable time frame, number one, and number two, if there's a significant period of construction in between that date and the receipt of it, then there's no ignoring of the practical realities of it. If you do it with and without today, your with today should consider, and this is, I've got a quote related to this, in the middle of page 3, the benefit caused by the proposed improvement, should reflect the time when it's actually realized. So there should be recognition of the delay in receipt of the special benefit in making the assessment. And normally that's not an issue, like I said, because we have an LID that may be complete in a year. But in the case of the Waterfront project, where 2, 3, 4 years may go by, that in my mind is a significant factor, and it's not addressed in the study.
Earlier today, you also discussed the fact that, in your opinion, the ABS study doesn't include a discussion of the cost of the improvements. Is that right?
It doesn't, right. Both before improvements and after improvements and the delta in the improvement cost, and also the increments that would be associated with various blocks along the waterfront. So, if a third of the LID cost is going to be in Overlook Walk, that's not addressed when looking at Pioneer Square assessments. There should be a proportionality of understanding as to where the investment is actually going to be made. And it's not discussed or presented in the report in detail with reference to the special benefits assigned.
Is it your opinion that the cost to construct the lid improvements should be part of the analysis in determining whether special benefits are accruing?
Absolutely. There's the LID ordinance has a test about cost versus, you can't be assessed for a benefit that is larger than the cost. That would be number one. But I think from a general, understanding, starting from a beginning sort of basis, is the investment of public dollars specifically in benefit of your property. That would be the contention. I believe a property owner is entitled to know exactly where and when those improvements, like the example we had this morning with the King Street property, exactly how much cost is going to be invested in Spring Street. I think that a person being assessed a portion of a special benefit would be entitled to know, okay, what is the cost associated with that benefit in direct proximity to my property? Otherwise, how can an appraiser really address what value additive it is? How just this large sum of money doesn't cut it. Where is it? How is it? How is it distributed? What's it going to pay for? Those are all very germane questions. And reading through the study, you never get a clear picture of where of where the money is actually being spent, where it would provide a tangible increase in property value.
So next I want to talk about this idea of the standard of error or the margin of error. Is that a synonymous term in your mind?
It works for me at the moment.
Okay. So there's, and you discussed this earlier today, this idea that the ABS study has identified an increase in value or the special benefit as being ranging from 0.5% to 4%. Is that right?
Less than 4, I think, is.
Less than 4,
Yeah.
sure. And you say in your letter that those estimates are below the standard of error or the margin of error, correct?
Yeah.
So could you identify for us what that margin of error is?
I felt I pretty much did. I mean, in my mind, the standard of error in an appraisal is, I mean, if you look at a group of sales in a class where there's, even the class may be identical, you will get differences in value, really related to different motivations, and incremental things, could get down to a very fine level. There comes a point where you can not distinguish a difference because of the noise in the data, statistical term noise. And so that standard of error, that noise component, if you're measuring, doing a matched pair sales analysis or a special benefit study, if you can't rise above the level of noise in the data, you you basically have a value or damage issue which is by definition not measurable. And a 1, 2, 3, 4% difference in the value of a 230-room downtown hotel when you don't even know and get this, it's on top of the fact you don't even know the mechanics of that operation. You don't know what its occupancy's been, you don't know what its room rates are, you haven't maybe even been inside the rooms. You cannot measure that difference. You just can't do it, can't be done. And certainly can't be done for 6,000 properties in one study. So I think, if the conclusion is there's a 2, 3, 4% difference, that's not enough. It doesn't rise to the level of a measurable benefit. And I think that's, obvious from the study.
So my question was, what is the margin of error? I'm looking for a percentage in a mass appraisal.
Well, I would begin at 5%, and in a mass appraisal, it's even higher than 5%. I would think a mass appraisal could be, I think there are certain properties where Mr. McCauley's estimate is off 20, 30% from what it should be. And so his standard of error is actually far higher than what he's measuring. If you did an individual appraisal on each property with all the data in that property, maybe you could get that standard of error down to, like I said, in the 5% range, 5 to 10%. So 2 appraisers with identical data would exchange reports and they might be within 5, 10%. But for a mass appraisal, you're not even close to that standard.
So have you actually determined what the margin of error would be in the study that ABS performed?
Well, I've just in talking with various property owners, I know that there are some, and I think this is later testimony by other appraisers that actually focused in on appraisals. I think you're going to see what kind of margin of error there is in certain specific properties, and it's a large magnitude. I haven't done it here because it's an impossible task. You would need to find out the actual value of each 6,000 properties and then compare it to the individual assignments of Mr. McCauley. But I would expect there to be vast differences because he doesn't have the information he needs on each of those properties to conduct an appraisal that's within a standard degree of error for an appraisal. So his master appraisal will be the margin of error, standard of error, will be much higher than that.
So let's just assume for the moment that the margin of error in this study was 5%. Just assume. And so when you say that the application of a 0.5 to 4% value change on a general mass appraisal basis falls well below the standard of error already present in such an analysis, that means that you're assuming a worst case scenario.
No. If you would ask me to assume 5%, that would be absolutely best case, actually unachievable standard of error in a mass appraisal. So he's saying he can distinguish a difference in the value of a property at a tighter margin than his appraisal is off. It's not possible to do. As just scientifically, academically, not possible to do.
But isn't it true the way, So when you create an estimate, like a political poll, right? You poll a subgroup of people and you gather data, and you weren't able to poll all of America, right? So you're working from a subset. And statistically, you arrive at a margin of error, meaning that the predicted outcome can fall, the actual outcome will fall within a range of the predicted outcome. Are you following me?
I'm totally following you, and I think that's a great analogy for how it's not like this. The purpose of this study is not to develop an estimate for a gross level of benefit to be applied to an area. That is not the purpose of the study. That might be the purpose of, say, a preliminary study or something, but the purpose of this study is to assign a particular benefit to a particular individual property. So in the analogy of your poll, it would be saying to someone, I can predict which way you can vote. And you absolutely can't do that from a poll. You can predict a universe of responses, but you cannot predict what that property will, how that property will be affected. And that's what the purpose of this study is. It's an individual assessment of benefit for each individual property.
Using a mass appraisal technique, correct?
That doesn't excuse.
Yes or no?
It is using a mass appraisal technique, yes. But it doesn't excuse the error, the standard of error.
Is it your conclusion that changes in market value cannot be measured under a certain percentage?
Yeah, under a certain percentage, you simply can't reliably distinguish if there is a difference.
So earlier you testified about some specific properties within the lid boundary, including the Embassy Suites and another hotel.
Courtyard Marriott.
Courtyard Marriott, thank you. Did you conduct individual appraisals of those properties?
No, I haven't.
And earlier you were stating opinions about whether, in your judgment, those properties would receive a special benefit from the waterfront lid improvements, correct?
I use some examples for that, yes.
Did you review whether the hotels advertise proximity to the waterfront in their marketing when rendering those opinions?
I don't know. That's highly possible.
You don't know if you considered that?
No, I don't know if they do or not advertise.
So it's something you didn't consider
No,
in your analysis?
it wouldn't be, no.
And in forming your opinion regarding those properties, did you assume that if a property wasn't immediately adjacent to the waterfront, that it would not receive a special benefit?
Here's my analysis of that. If the term special requires some understanding of the relationship between that particular property and the improvement. The further that improvement is away from the property, the greater the burden on the appraiser in addressing the degree to which those improvements are special. And I pull these ones out because when you do that, it actually looks like they're profoundly not just average, but below average access to those features of the park which are considered to have value. So again, the study has the burden of proof to prove that those properties are special benefited. There is no way, once you get into them, of seeing where that comes from. That's why I pulled those ones out.
So turning back to your letter, page 6. You talk here about how it is inequitable to value improved and unimproved land without just considering the increase in value to the land itself. Is that correct?
Right, yeah, you should be looking at the land.
Just the land, not the improvements?
Well, it's not just the land, but you should be factoring that if there is a benefit, it will increase the land value, not the improvement value. You also need to consider what's on the site, but you're really, the application of, in measuring a higher value, you're really looking for a higher land value, if there is one.
So last week we learned a lot about valuing hotels. And so I'm going to propose a hypothetical to you. Let's say, because you have examples here of some buildings, an apartment building and a parking lot, right?
Yeah.
So let's say that you had a hotel with a fully constructed building, it's been in operation, and then you had a vacant lot. Is it your opinion that the improved hotel would not receive any special benefit associated with its improvements as opposed to a vacant lot?
Well, a vacant lot, if always vacant, but that's not the case. So you have to look at a vacant lot as, and in your example, let's say the vacant lot would support a hotel identical to the one next door. If you evaluate the hotel property that's complete as different from the vacant lot with the proposed hotel on it, when the proposal is going to result in that being a hotel at the time the improvement, special benefit improvement is delivered, then you've created an inequitable assessment between two properties, like we had here, $625 a room versus $10,000 a room. That's a lack of proportionality. When the Citizen M Hotel, for example, is going to be built in 18 months, when you don't consider that, when you evaluate that property, you result in a disproportionate assessment between a hotel that's right on the boulevard versus one that's several blocks away from it. How could that happen? How could 2 and U on page 6 go from $600,000 to $4 million of assessment within a year? It's because his methodology is wrong. You should be looking at the value lift associated with the land component, and then it would have been the same lift. The property would have been evaluated as though with imminent construction of a high-rise, and it would have been evaluated similar to an existing high-rise. Not done. So that's the error that he's done there. And it's aptly proved by looking at the results of the analysis and the disproportionate level of assessments between properties.
But assessing special benefits, earlier I believe you said it does involve figuring out what the fair market value of the property is that right?
Yeah, but it's not related to fair market value. This actually goes to the core of the error. Because he has not measured differences, he's applied them. He's applied a percentage difference to before values, and sure, those are all fair market values, let's assume that, and he's applied this difference equally to these before market values. But the problem is, unoccupied land versus an improvement, the unoccupied land is going to get a very low assessment if you do it that way, when in reality, if it were true, the land value would increase and the tower that was built upon it would be more valuable as a consequence. He has not considered that. I realize it's a complicated issue, and But if you go to the result of the analysis and you take side-by-side properties, vacant land and improved properties, you see how it's disproportionate. No one could deny that Citizen M at $625 a room is disproportionate from, Courtyard Marriott at over 10,000. Those are disproportionate. They're both hotels. And it's because his methodology is wrong.
One of those hotels isn't currently built, though, correct?
But if it's going to, land isn't land forever. If land were land forever, then that would make a difference.
But one of the hotels you're discussing hasn't been constructed.
Yeah, but he's meant to evaluate the property under its highest and best use, which includes a hotel being built upon it. That's the proposal. He's meant to evaluate it under that use, and he hasn't done that.
No further questions. Thank you.
Before we go to redirect, I have a few questions for Mr. Gibbons. Mr. Gibbons, you've indicated, I want to get a clear idea of the of your testimony concerning margin of error. Is a mass appraisal always going to have a margin of so let me take a step back to a regular appraisal. It seems like the regular margin of error is around 4 or 5. Is that what I understand from your testimony?
I would probably put it at 5% plus,
Okay.
yeah.
So we'll say
Yeah.
5%
Yeah.
for just
Yeah.
a standard property
Yeah.
appraisal. Is a mass appraisal always going to have a margin of error higher than that?
Yes, it is. Yeah.
Okay. And why is that?
It's because the very nature of the mass appraisal means that you are not going to you do not have the time, frankly, budget to evaluate each individual property. If you were doing an LID for a sewer with 26 properties, you could probably get very close. But with 6,000 properties, no way. No way are you going to get to avoid a huge amount of error in the analysis.
And so if a mass appraisal is used to determine a special benefit, is there any type of rule of thumb for amount of benefit that's identified where you can't go below that? So for example, here, if you're saying they did a mass appraisal, a benefit is less than 5% in all cases, they can't do that because it's within the margin of error. So you cannot, is it the case that you would say you cannot do a special assessment for something less than that?
That's well said. If you started at the outset and said we can only show, all the work we've done, we're only looking at a 2, 3, 4% increase, potentially that we are able to measure, and you lay out the map of downtown, the conclusion would have to be, I can't reliably measure the after value sufficient to support that estimate, and therefore it can't be done. Now, the reason that it would work in other cases, again, a sewer LID is so perfect. 20 properties going from a septic to a sewer might be 50, 60% increase in the value of that property. Clearly, you're going to meet anybody's expectation of a reasonable measure there of just in terms of magnitude of where the values of the property would be before and would be afterwards.
What if you had an extremely valuable property, let's say Mercer Island, Waterfront, or something like that? You're going to add sewer. It's not going to do it by 50%, but we all know it's going to add something. And the appraisal's in that 5% value. Is it just not achievable or retrievable by that jurisdiction?
If you've got an issue which, like that, I would look at potential cost avoidance for that property. So in that particular case, if I found that high-end waterfront homes with septic systems, they either sell for less than ones on sewer. That would be the first test. I go out and find, but your point is well made. If we went out and did a study on Mercer Island, and we had sales of property with septic systems on the water and sales of property without septic systems, I mean with sewer systems on the water, and then we say, okay, well, do they have docks or no docks? What about the views, size of lot, amount of waterfront? And you start crossing off these things to create a matched pair. And if you get down to a point where we're talking about $5 million of real estate, and you have properties with functional septic systems, you may not have a difference. But you get down to a point where you feel like you either go to cost avoidance, like septic system costs money to maintain, et cetera, if you're looking for an incremental issue. But if you can't find it in the data, then it may be that there is no benefit to the sewer because they've got extremely elaborate septic systems.
So if I understand what you're stating, it's that maybe there's no benefit, or to get there, you need to do a more granular study.
Exactly. You need to look at, cost avoidance. If you had street improvements in front of a property, are those street improvements you'd have to put in if you were going to develop? And so you have a cost avoidance issue. That would be great, sort of a granular example.
Okay. You have in Exhibit 41 your letter from January 30th, 2020, a list of different concerns that you raise with the city's process. What I'd like to do, if we can, very quickly, if you can just bullet point your points for me. I need a very quick outline of what the point is, just so we can use that for an exercise I want to do after that.
Okay.
You don't have to, I don't want full explanations of these items. I just
Yeah.
need, in your own words, a bullet point for the points, so that I have an accurate list of all the points you're raising.
Okay.
That's all I'm asking you to do.
I think I've got it. No establishment of general benefit is number one. Benefit is assigned, not measured.
Okay, let's slow down. So
Sorry.
benefit is not is assigned, not measured.
Yeah. Benefit assigned, not measured.
Okay.
Before, the value of before improvements is not taken into account. So there's no true before is what I call that.
Okay.
Because of the nature of the manner in which the actual assessment is being applied, it creates inequities between property with proposed improvements versus property existing, that last series of questions. So you could have a property.
So what's the one phase line to describe that? Yeah.
Inequitable assessment between properties with similar highest and best use.
Okay. Let me finish writing that.
Yeah.
Okay.
Okay, I've only got two more. Number 5 is the property type, downtown high-rise residential real estate, in my opinion, does not reliably lend itself to a mass appraisal exercise of this type.
Okay.
And the final thing is the benefit identified falls below the standard or margin of error that's already implicit in the data and by definition cannot be measured.
All right, thank you. That's helpful just to have a quick outline of that. That'll be in and of itself, it'll be useful, but I also wanted to use it to ask another question.
Yeah.
In that, I know you don't do this all the time, but do you enough to be familiar with sort of the challenge I have is, if an expert is in front of me, there's a range of concerns they may raise with another expert.
Mm-hmm.
And I need to evaluate and prioritize with what you're stating against it and give it some type of evaluation on that level. And so one differentiation, for example, is some of these, or maybe all of them, may be raised as issues where you're concerned about a failure to meet appraisal industry standards. This is just not a good appraisal.
Right.
Others may be, it could be a better appraisal. I think these are, if I was doing it, I would do this, but it's within industry standards. Can you, for each of those items, tell me which of those you're aiming at? Meaning, is it, and I can repeat that.
No,
for
I
each-
got it.
Okay,
I got it.
so for each of those issues you raised, and there are 6 issues, are they, this appraisal simply does not meet industry standards, or I would do this differently within my best practices?
Yeah,
which is a different item.
I got it. In my opinion, 1, 2, and 3 are, in my opinion, that does not meet what I would consider the industry standard for this type of mass appraisal LID study. That no identification of the general benefit, benefits are not measured, they're assigned, and there's not a precise quantification of what the actual before condition. That's a little unique here because the before condition isn't built. So to me, that puts a different burden on the appraiser. So those 3, 4, 5, and 6, standard of error issues, property type doesn't lend it to inequitability. I think those are more judgment issues that if you could get past 1, 2, and 3, then you would start to saying, how can I deal with these issues in a different way? So does that help?
That's very helpful.
Okay.
Yes. Counsel for the city, do the questions I've raised, do you have any questions based on that before we go back to redirect?
I think if I could, I'll return to our favorite margin of error topic. Just because I think what I was trying to,
And what I'm really asking is,
Did you-
create a new, not so you can start
Sure.
your line of question again, but
Sure.
I have asked questions that may have strayed into territory you did not have an opportunity to address and/or raise new facts. And so I want to make sure that you have an opportunity to address those. If not, then I'll go to redirect.
okay, just 1 second, let me review my notes here.
Sure.
Okay, I just have a short follow-up. You stated that on your list of issues with the ABS study, numbers 1 through 3 you qualified those as issues that don't meet industry standards for a mass appraisal of a local improvement district special benefit study, correct?
Yeah, those are things I would expect to be de rigueur for a study, have to be in there.
Earlier, you testified that you did not review the ABS study for compliance with Standard 6 of USPAP, right?
Yeah, I didn't.
And those are the standards that govern mass appraisals, correct?
They govern mass appraisals, but this is particular to an LID study.
No further questions.
Thank you.
And I have just
Redirect.
a couple. Let's start off, Mr. Gibbons, with the topic we were just discussing, the 3 errors that you would call more, failure to meet industry standards, and then the 3 that are more judgment issues.
Right.
Is it possible to separate those errors, or do the first 3 errors, what impact does that have on the evaluation as a whole?
Well, I think some of them I feel like would be critical failure errors anyway, like not within the standard of error. To me, I just don't see how that could be done. I'd have to see how somebody could try and do that. I don't think that could be done. But obviously the inequitable between properties is very much a judgment issue in terms of, I think it just shows how, I think the study is wrong, but I feel that's more of a judgment issue.
And just to pause for that,
Yeah.
I mean, you could remedy that inequity, right? I mean,
Yeah.
I mean,
yeah,
that's easily
yeah,
remedied, right?
Yeah.
Okay.
I mean, we tried with one of the properties and we didn't get a response, you know. So I think those, you know, yeah, those are explanation, look at what's happening here, this kind of thing. So those could be remedied, yeah.
Okay.
Yeah. But yeah, so what, sorry, what was
So
your question?
so what impact is the fact that there are 3 of those errors that you have not identified as being judgment errors or not able to be remedied?
They add, I mean, everything is additive. You know, like I said before, I felt like these series of issues in and of themselves, I think they represent critical failures, you know. And whether they're critical failures of judgment or missed standards of what I'd expect to see in an LID study, like measurement of general benefit, you know, that should be in a special benefit study when there is general benefit. So so again, you know, and assigned, not measured, you know, those are huge issues. So
Right.
yeah.
Right. You talked on cross-examination about some, I think they were called council-created documents. Were you referring to the handout and the slides that Ms. Ducombe started with today?
Yes.
And do
yeah.
you know where the information in those slides came from?
I think it was all pulled from the various materials, somewhere I think EIS materials, somewhere in the addenda, where we pulled out the individual discussion on what's actually applied for
Okay.
individual properties. Yeah.
And let's see. On the issue of the ABS study's failure to identify the general benefit arising from these improvements, is that a calculation you would have expected to find in the actual study or in its addenda?
Yeah, no, it should be up front.
Okay.
You know, it mainly due to the nature of the type of improvement. You know, this is, again, if it was a sewer LID, you know, you could probably skirt the general benefit section to this will generally improve, you know, commercial or residential property in the area. But because the special benefit for property is so incrementally easy to find. Here, it's the opposite, actually. You know, this is a very broad improvement in the economic center of the Seattle area. You know, I would expect there to be a massive attention paid to how much of this is general and how much of this is special, particularly if there's going to be an identification of an LID boundary, which includes 6,000 properties, you know. So.
And I have the same question about the loss of parking. Again, is that something you would have expected to be actual calculations reflected in either the study or the supporting addenda?
Yeah, because we, this actually came up in one of the meetings earlier, and as I came out of the meetings, I met, you know, just happened to talk with some of the pier owners down there. And yeah, parking down there is a huge deal, you know, for their piers. And I don't think people have really realized what was going to happen to that. City was going to try and buy the Wilson lot to provide more parking down there. That didn't work out, although they might be still working on a deal there. So the issue is, I think if you're going to write a study that granularly measures a 3% increase and you don't get into parking, which is you know, renowned as an impact on retailers, you know, that's all they talk about is how much parking there is, then to me that's a huge omission. You know, it's just, the issue's kind of skirted over. And yet, at the same time it's skirted over, and yet we're granularly going to measure a 3% difference.
And then finally, you talked about the issue of timing and about how, in this context, it's not appropriate to use the valuation date and the improvement date as the same valuation date because the benefits itself aren't going to be enjoyed for such a long period of time. How would you have tackled that for this?
It is complicated because you could either fast forward to the date of when the improvements are delivered, but of course the problem is there's this period of construction in between. The other problem is the before improvements aren't built either, you know. So it's a challenging issue. Probably if I was going to do it, I would have valued it as of a particular date when without, because I think that's sort of easier to present. And then I would have said, you know, the allocation of value should consider that these improvements actually won't be present for 3 and 4 years. So you could value it as an anticipation of receipt, but they're actually not going to be there for 3 or 4 years.
And do you also account for the fact that there might actually be damages during the time that the special benefits are that the improvements are being made?
Right. So then that would relate to construction impacts from, you know, in sort of similar manner to the viaduct coming down, great benefit, but at the same time, you've got the jackhammer in front of your property for several months. You know, clearly, you know, there's more to it than just a with and without, you know, if you're going to look at the viaduct as a special benefit issue.
Those are all of my questions.
Thank you.
Thank
Thank
you.
you, Mr. Gibbons.
Thanks.
Objectors have another witness.
Don Ayers?
Please state your name and spell it for the record.
Don Ayers, Don, D-O-N-A-Y-R-E-S.
And do you swear or affirm the testimony you will provide in today's hearing will be the truth?
I do.
Thank you.
We're going to just start out real quickly with the notice of assessment. I've handed up, Your Honor, 5 exhibits, the notices of assessment for these objectors. Do you need a second set?
No.
Okay.
I did. What have I got here? What have you-
These are the notices of assessment, which we
For
just
all
like.
of the cases we're hearing?
Correct.
Okay.
And we'd just like to offer those.
All right. Let's just mark them
What,
as...
do you want to, oh, they're all individual.
Actually, sorry.
Let me fix that. We'll go one at a time. Hand me this,
Oh,
hand me your
wanna
check.
see them? Sorry.
Okay, I'm going to hand you one, Don. Read that to us. Tell us what you see there.
This is a notice of assessment from the city clerk for 1000 First Avenue South, LP.
We would move to admit
The Exhibit 43.
43, the tax assessment for 1000 First Avenue LP, parcel number 76662066678. I'll add you the second one for 1000.
Yes. Again, another notice from the city clerk for 1000 First Avenue South, LP. You want me to read the number? or you
Sure,
gonna-
why don't you read the parcel
Yeah,
number,
okay,
too?
so this parcel 7666206676.
Thank you.
Marked as Exhibit 344. No, sorry, 4444.
Here's the next one, Don.
All right. Again, another notice from the city clerk for 618 Second Avenue Limited Partnership, parcel number 093. 9000080.
Read off for that as an exhibit, Your Honor.
Case number 337, exhibit number 45.
Here's the last one.
All right. And finally, another notice from the city clerk. This is for 255 South King Street LP, parcel 766-620-4878.
Okay, one more.
Oh, yeah, no,
1016, we can't forget 1016.
yeah.
That's case number 336, marked 46, exhibit 46.
Okay, and then final notice was for 1016 First Avenue South LP, parcel 766-620-6690.
Case 342, exhibit number 47.
Mr. Ayers, can you just briefly describe for us your background in working for these properties, on these properties?
Yes, sure. Yeah, well, I'm a principal of American Life, and I am more specifically the property manager for our company. I've been doing this for about 16 years, both in terms of helping acquire the properties, to help build them out, do the tenant improvements, lease them up, and then manage the properties subsequent to all that.
Can you talk to us just briefly about the Courtyard Marriott, its location and
Yes,
what's
well.
unique about it?
Yeah, well, the Courtyard Marriott is 618 Second Avenue, and for, I guess, identification purpose geographically, it's about 2 blocks south of the Met. Everybody understands where the Met is. It is close to City Hall, and kind of the Pioneer Square area in general, and I guess other than that, its geography is about maybe 3 or 4 blocks from the waterfront, I guess. So I suppose that's about the right distance.
And looking at the assessment for 618, I think if you turn to page 3, can you tell us how much the assessment was for 618?
What exhibit number are you using, so we can keep that in the record?
Keep track?
Yep, sorry.
Yeah, here,
It's
I've got it here.
45.
45, exhibit 45?
So it's for, you want the assessment for?
618 Second Avenue?
618, yes, okay. So the proposed final assessment for the lid is $1,005,415. Or $1,005,415. So a
Thank
little,
you.
about $1 million.
And in your experience trying to manage and let the property, Courtyard Marriott, what have been the unique challenges there?
Well, I think we've had several, number of which have been created since we built it and refurbished it. So we have the traffic congestions with the bike lanes, which is a little bit of a problem. We don't really have a parking lot. We leased the Triangle parking lot down the street. I think the homeless issue has been a very large problem for us down there, like most of the Pioneer Square area tenants. And I think just general vagrancy, I think, is our biggest issues.
I'm gonna, I thought it'd be helpful to bring up the map for your honor. This is Exhibit 3.
Exhibit what?
Exhibit 3.
Which page?
I believe 15. Is that the map?
It's 18 in this one.
18 on that one. And what can you tell us about the distance that the Courtyard Marriott is from the intended improvements?
Well, as I said, I think it's about 3 or 4 blocks from the intended improvements on the waterfront. So that's the proximity to look for. That's what I think it is. So.
And does the Courtyard Marriott have mature trees, landscaping?
No,
Does it have sidewalks?
it does.
Okay. And maybe we can turn to a photograph. Page 21.
Okay,
Got it?
I do.
Okay. Is that the Courtyard Marriott?
It is.
And are those trees next to your property?
They are. They're in front, I believe.
Okay. Is there anything that you've learned about the intended improvements for the waterfront that are of unique value to the tenants or customers at the Courtyard Marriott?
Not to my direct knowledge, no.
What would you say about streetscape and landscaping several blocks away? Do customers come to the Courtyard Marriott for that?
Well, a better person to ask that question would be the manager, but I don't believe so in my interactions with them. I have not heard that, no.
Okay, great. Let's go on to 255 King Street.
Okay.
What number is that?
46.
46. Can you see the assessment there?
I am turning to it right now, yes, I do.
And how much was the assessment for 255 South King
Okay,
Street?
the final LID was $923,916 and some change.
And what can you tell us about 255 South King Street?
Well, it's a relatively new hotel. It's about 2 years old in terms of its opening, and it sits in the very north, or excuse me, the very north end of the Questfield parking lot. It's uniquely centered kind of between Pioneer Square and the Stadium District, and next to the train station. So I think those are the geographical kind of boundaries. If you're looking for my opinion of where it is to the waterfront, it is many blocks away from the waterfront project, and I'm not certain what else to tell you other than that.
Yeah. And it's a twin tower development, is it not?
It is, yes.
And what's in the other tower?
It is a project that has obviously the Hilton Embassy Suites, and then an adjoining structure of about 23 stories of an office tower on the south side of that, south side of the Hilton.
And what's unique about this development in terms of its neighborhood, its surroundings? What drives the tenants to come?
Well, I think a lot of it is obviously generated by the game days and by the sporting events around the area, and that's where our biggest impact is in terms of being busy and being occupied. That's the hotel side of it. The other side of it is a full office building that's completely been tenanted and has been tenanted almost since day one. So we have a variety of tenants in there, but there are no retail tenants in there other than a restaurant on the ground floor of the hotel.
And what interest did the tenants have in the building? What was special about it for them?
Well, there were
Objection.
several things.
Hold it, there's an objection.
Objection calls for speculation.
Were you involved in leasing up the building?
Are you
Don?
withdrawing the question, or
Or-
you have a response to the objection?
No,
It's-
well, I believe he just
You're withdrawing
testified
the
that he...
question?
I'm not withdrawing the question.
An objection was made,
For speculation,
yes.
and he testified that he leased up the building.
So you're going to take the testimony over the objection?
Well, I was just going to lay up another
Okay.
foundation if that was
I'll allow it
needed.
to be stricken if you're not
Okay.
going to respond to the objection.
Well, I just responded that it's not speculative if he has knowledge.
I didn't hear you. You're talking
Oh.
over me. So
Oh, sorry,
I've
sorry.
been asking for a response to the
Sorry.
objection. This is the first time you've provided
Sorry.
it. What's your
I
response?
don't believe it's speculation because he has personal knowledge about leasing up the building.
Okay, with the tenants?
Yes, he just testified to that a minute ago.
Okay, I didn't hear that part.
Okay.
Maybe that's, with that, is that?
You were asking what the tenants thought. He's not a tenant,
Okay.
so.
I'll allow it. We do hearsay in these hearings pretty
Well, all right,
commonly.
so
to
could
the-
you repeat the question?
Sir,
I've
please
forgotten
don't talk
now.
over anybody in this hearing room.
I'm sorry?
Please don't talk over anybody in the hearing room.
Sorry. Okay.
That's, and I, just shouting so you can hear me. That's-
Got it.
All right. We just, for recording purposes, we all need to, counsel and myself, we all need to talk one at a time. So please proceed with your question.
And so in leasing up the Avalera Tower, Hawk Tower, what were the issues?
There were three. A lot of the people in the tower that were the occupant owners of the business came from Vashon Island, wanted to be close to the ferry. The second was they wanted to have proximity to the nexus hub of transportation and ingress and egress from the building. And the third is they wanted it to have a look-alike feel from their building and their business back in South Carolina, which is next to stadiums.
All right, thank you. And so turning to, oh, yeah. Let's see. And so, do you have this packet in front of you with the photos? Hearing Examiner's Exhibit 3, I believe it is. It should be 2 pages back from the Courtyard Marriott photos. Page 20, possibly, 21, 19, 20.
Yes, I have it.
I'm not, you just listed three
Are-
different pages.
Yeah, are you on Exhibit 3, page 19?
I'm
which
on
of-
page 20.
And which photos are you looking at there?
Aerial viewpoints of the Hawk Tower?
Okay, the before and after?
Yes.
Okay. And does that reflect the development site before the building went in?
It
And then
does.
after?
Yes.
Okay, thank you. Now turning back 1 page. Are those also photographs of 255 South King Street?
Yes.
And does 255 South King Street have sidewalks
Yes.
and has trees?
Yes.
Was that something that you were required to do as part of the development?
Yes.
Thank you. Okay, turning to First Avenue South. Do you have exhibits 43 and 44? You have both for 1000 First Avenue South there? One has the 76 number and one has the 78 parcel.
I have them.
Okay. Can you let us know which one you're reading from? And then tell us the amount of the assessment?
Okay. This is for parcel number 766-620-6678. The proposed final LID was $13,713 and change.
Thanks.
Okay.
And then for the other property?
Yes, this is for the parcel ending in 6676. The proposed final LID assessment is $44,667 and change.
And then in that document with the photographs there where we just reviewed 255 South King Street, if you turn 2 more pages,
The documents exhibit number for the record, please.
Exhibit 3, Your Honor.
Page 23.
Mm-hmm. There should be a few pages with the First Avenue South. The first picture should be all three properties highlighted. Do you see that?
I am looking at page 23,
Do you have 22?
22. I do.
And are these the 3 properties that we just received, you just received notices of?
Correct, yes.
And where are they, oh, right, and where are these located?
Proximity-wise, the CenturyLink Convention Center, we're directly across the street west. And so Occidental would be the street, and then First Avenue would be the west side of the buildings.
And what's the proximity or distance to the waterfront from here?
Oh, probably 5 or 6 blocks.
And what were the issues in leasing up 1000 First Avenue South, the Palmer Building?
Primarily, there were several. The biggest one was the construction outside of the building for 4 or 5 or 6 years, and all of the dust and all of that. And then there was a large population of homeless that inhabited the area, both in and around the building. And so those were our 2 greatest issues.
And who are the tenants there now?
In the 1000 building, the Palmer Building, is a company called Payscale.
And does this building have sidewalks and landscaping and trees?
It has trees on the west side. And yes, there are sidewalks.
And then if you turn the page, is that a picture of 1000 First Avenue
Yes.
South? And then I'm going to ask you to look at the assessment for 1016, which you should have in front of you.
Okay.
Exhibit 47, Your Honor.
Okay. Yeah. Yes, here it is.
And can you turn to page 3 and let us know what the assessment was for this
I can.
property?
Mhm. So the proposed final LID assessment is for $20,374.
Thank you. And if you turn to the last page in that packet for Exhibit 3, I believe there's a photograph of 1016.
Yes,
Is that 1016?
that's correct.
And who's the tenant there now?
There are several. We have a company called Forma Construction is on the 4th floor, the top floor. The 3rd floor is Office Depot, Office Max Corporate Office. The 3rd floor, or the 2nd floor is vacant, and on the 1st floor is a company called Hat World, which is a professional and college apparel company, sells apparel.
And what were the issues leasing up this building?
It was largely the same, the construction and the noise and dust and the homeless issue, and those were our large, and we also hit the stride in the 2008 to 2012 recession, so.
And does this building have sidewalks and trees?
They do, it does.
Thank you. Just a minute here, let me double check. More further questions, Your Honor?
Thank you. Cross.
No cross. Thank you.
All right. Thank you, sir.
Thank you, Don.
Okay.
Now we're proceeding with objectors.
We have an additional witness.
Okay.
We can either call her now or take a break and then call her.
Yeah, we'll take a break, but
Okay.
I'd like to know how much time you
Um,
anticipate for when we come back.
So I think, so we have 2 additional witnesses lined up. I think each will take about a half hour.
Okay.
Just for our questioning, and,
Mhm.
yeah.
Sure. All right, we'll return at 3:15.
Thank you.
And we return to the record and continue with the objector's case.
The objectors call Christine Cole.
Please state your name and spell it.
Christine Cole, CHRISTINECOLE.
Thank you. And do you swear or affirm the testimony you will provide in today's hearing will be the truth?
Yes.
Thank you.
Ms. Cole, where are you employed?
Soto Builders.
And what do you do for Soto Builders?
I am a project manager.
And were you the project manager on the building constructed at 255 South King Street?
Yes.
So what did you do as the project manager?
Negotiated scopes of work, wrote contracts, change orders, managed the budget, invoices, etc. Answered questions.
And were you the project manager throughout the term of the project?
I was one of them, yes.
Did you interact with subcontractors, third parties, or was it only mostly internal?
No, I did interact with subcontractors,
Okay.
yes.
In front of you, you have Exhibit 3, which is a PowerPoint presentation. And if you switch, if you go to page 21. Okay, let's actually make it page 20. Can you tell me what those two pictures are?
Those are aerial sky pics that we took at the beginning of the project and the end of the project.
Can you give me a ballpark time for, or at least a year for the before picture?
It's April 14, 2014.
I'm impressed you can read that. When was construction completed?
This after photo was taken April 28th, 2018.
Okay.
Construction was completed mid-March of that month.
Of 18?
Yes.
Okay. Can you turn to the prior page, page 19? And are those pictures of what the 255 building looks like today?
Yes.
All right. In your binder, you will see tab 53. If you could turn to that, that would be great. Okay. And if we could just walk through these photos. On the first page, can you tell me what this is a picture of and where it is in relation to the 255 building?
Are you going to give me a copy?
I'm sorry. Yes. Exhibit 53.
Tab.
Tab 53, not Exhibit 53. Tab
So
53.
What's the exhibit?
I'm going to offer it into evidence.
Okay. Okay, go ahead.
It is the south side of the south tower.
And is this Exhibit 48?
This will be 48, yes.
And this is the south side of the south tower?
Correct.
Okay, so this abuts the north parking lot of the field?
Yes.
Okay. And are these, the sidewalk that's present here, is that something that Soda Builders put in?
Yes.
Okay. And what about the picture immediately below it, still on that first page?
That is a longer shot of the same photo above,
Okay.
just to see the sidewalk piece from the other side.
Great. Could you please turn to the second page? What direction is that the top picture facing?
The top picture is the north side of the north tower facing east towards King Street Station.
And what about that lower picture?
The lower photo is 2nd Avenue facing south towards CenturyLink Field.
Okay.
On the west side of the towers.
And are these current depictions of what the sidewalks and landscaping look next to 255 today?
Yes, these photos were taken maybe 2 weeks ago.
Okay. And are these sidewalks that 255, that went in as part of the 255 construction project?
Yes, they did.
Can you turn to the third page of this exhibit, please? And can you tell me what the picture is on the top page, or top of the page?
The top of the page would be the northeast corner looking east towards King Street Station.
So,
North side of the north tower looking east towards King Street Station.
excellent. And what about the bottom photo?
It is the north side of the north tower looking west.
Okay. And again, this is a current depiction of the sidewalks and improvements around 255?
Yes.
And finally, the final page, what direction is this picture facing?
This is the east side of both towers facing south towards CenturyLink Field.
And again, this is a current depiction.
Yes.
And are these improvements that were made as part of the construction for the 255 building?
Yes.
Okay. And are you familiar with the work that the Soto Builders and its subs did outside of constructing the actual tower, improvements made to the sidewalks, streets, and rights-of-way?
Yes.
Can you describe those briefly for us?
Before we could start construction, we had to move King County's odor control facility out of our property into an easement, as well as Seattle City Like's duct bank. That was prior to construction. I'm sorry, what was the part of the question? What improvements did we make?
Yes.
Okay. Obviously, all these sidewalks, curbs, gutters, a bunch of landscaping, planters. There's granite pavers out in front of the hotel to the atrium that actually enters both buildings. We also improved King Street. Half of King Street was repaved, as well as a new crosswalk etching went in, and we also put some ducting across King Street for Seattle City Light. We put in new street lights, obviously the curbs, gutters, driveways, etc.
And why did you make these improvements?
They were required by the city.
Can you please turn to tab 54 in your binder? And I would offer this as Exhibit 49.
And I'm sorry, which tab?
54? Ms. Cole, have you seen this document before?
Yes.
What is it?
This is the street improvement plan we had, that was approved by the city.
And if you turn to the final page of this document, can you sort of walk me through the kinds of work that you did on King Street?
We had to replace the sidewalks. They were broken and uneven, I believe, from the trees that were there. We also had to do maintenance on the trees by a city-approved arborist as the city watch, since that was true. And then it also shows how we had to repave half of King Street and the sidewalk painting that we had to put in. Towards the middle, it shows the new street light we had to put in. Towards the left-hand side of the page, it says remove existing pole and luminaire. So we had to take down an existing pole that was there and light and move it. And then towards the right, it just kind of shows the improvements that we had to make to get the grade for our driveway, as well as King Street, stations, parking, and et cetera, even.
I'd like to talk about the costs that were involved in that. I have a new document.
50.
50? Ms. Cole, have you seen this document before?
Yes.
At the same time, I would like to turn your attention to Exhibit 55. It's behind tab 55. And ask that that be marked, and that would be Exhibit 51. Let's turn back to Exhibit 50. Do you know how this was created?
Before you move on, we're marking this as 51, the lid backup cost information.
Yes.
How much of this are you going to use?
Almost none. It's the backup cost for the amounts reflected in Exhibit 50.
It's pretty thick.
I know, well, all the backup numbers are there.
Not going to use it, though. I mean,
Well, I mean, we want to lay a foundation so that there aren't questions about whether we actually spent the amount of money that's reflected on the cost summary. I mean, you'll find, if you would like me to walk through the cost documentation to show that the numbers match, I'm happy to do that. That wouldn't actually take very long.
I'm not questioning the document. I'm
Okay.
questioning submitting all of this. That
Yeah.
Seems we're getting further stray from
Okay.
what we need to be getting in, and it's just creating a large record. I'll allow it for now.
Okay. So, Ms. Cool, can you tell me what Exhibit 50 reflects?
It's the summary of the lid backup costs.
And what specific backup costs?
You want to go through the line items? Is that
Yep.
what you want? Okay. So stone masonry, fountain, landscape walls, benches, tile, pavers, those are on the exterior of the building. They are granite pavers that you walk on, or they're walls that were landscaped with stone, or stone benches that are out there for the public to sit on.
Okay.
The odor control facility was moving King County's odor control facility as it would run through our building. The lighting is adding the one Chief Sealth street light on King Street, plus, I'd have to look at the photos, it's 3 or 4 additional light poles on 2nd Avenue, as well as lighting for landscape, trees, etc. Street restoration is a little hard to understand why the dollar value is so small. That really is concrete walls for the planters that were then covered with stone. Asphalt paving and permeable paving were King Street being paved, 2nd Avenue being paved, and permeable paving on the south side of the building as well as the east side of the building. Right-of-ways, sidewalks, and driveways are fairly self-explanatory, sidewalks, driveways, etc. Curbs and gutters are part of the sidewalk system. Irrigation is for all the landscape planters at the street level. Landscape and tree grates are, again, self-explanatory. They're landscape in the planters along the street and in planters close to the building, as well as tree grates.
Just to be clear on this one, why did you do the landscaping near the building?
It was required
By
by the city
Okay.
per the green factor.
Okay.
Water was putting in a 1-inch new water line to the Weller Street Bridge. The sewer was to repair the damaged sewer to the Weller Street Bridge when King County put in the odor control facility. The storm drain was an enlarged pipe that we took down to the stadium for them. The electrical transmission and distribution was moving of SCL's duct bank that ran through our property, as well as putting some piping across the street for them on King Street.
Do you know how this document was put together?
Our estimator put it together based on me pulling all the contracts and change orders that were issued to subcontractors during the project.
And those backup documents are reflected in Exhibit 51?
That is correct.
So in total, the cost for these sorts of improvements was more than $3 million, is that right?
Yes.
Did you make any other improvements to the area that aren't included in these costs?
There are $3 million worth of contaminated soil that was removed from the property prior to the building commencing construction when we dug the hole. There's also fountains, artwork / sculptures, lit gabion walls, etc.
Why did you remove the contaminated soils?
Objection. I would object to this line of questioning. I don't see how this is relevant to this proceeding, which involves the assessment to particular properties.
Right, so our position is that 255, the Embassy Suites building, should be entitled for an offset for improvements that it already made particularly because they are so akin to the improvements being made to other property owners within the lid.
The cleanup of the site?
Well, not the
I
cleanup.
mean,
of
I
the
got
site.
the sidewalk,
Yeah,
but
yeah.
we're now talking about site cleanup.
Well, it's just,
And that's what the objection's to.
okay,
It does seem irrelevant.
I'll withdraw it.
Okay, thank you.
Thank you for your time.
Any cross?
They might have some questions.
Oh, I guess one question I had, you mentioned the green factor.
Yes.
Was what drove the required improvements. Could you just,
For the landscaping.
oh, for the landscaping. Okay, could you explain
Sorry.
what that is? No, okay.
No, it's to the best of my knowledge, it is a certain percentage of the project needs to be green, and that is a city requirement. I don't know how that's determined. That was done by our architect and landscape architect with the city.
No further questions.
Any redirect from that?
No, Your Honor.
Okay, thank you. Just want to make sure we're caught up with exhibits. We did just mark and admit exhibits for a period when council was introducing them, but I haven't been doing that, waiting to see if there's any objections on some of these others. So I'd like to, we're up to 51 now. What were we admitted to? That are marked admitted. These are, all of these are not marked admitted.
Then it was,
Let me check to see where we are on admitted exhibits. Do you have it in your notes? No, you need to keep track of that. No, just the ones that council was. All right, from Exhibit 32 to 51, were there any objections to those being admitted?
My only objection would be to the last two exhibits, 50 and 51, on the basis that they're irrelevant.
Any response to the objection?
I think my response is the same as my response to the objection during the testimony. 255 is seeking a credit for the amount of public improvements that it already made as part of its construction project, most of which were required by the city. And it is our position that those amounts should offset the assessment at issue here.
Okay, for that limited purpose, they'll be admitted. So exhibits 32 to 51 are admitted. And we're caught up on that. Next witness from objectors.
The objectors call Nick Coons.
Please state your name and spell it for the record.
Nicholas Coons, Nicholas. Coons, Kuhns.
And do you swear or affirm that the testimony we'll provide in today's hearing will be the truth?
I do.
Thank you.
Good afternoon, Mr. Coon.
Hi, how are you?
Tell us what your current position is?
I'm the hotel general manager at the Embassy Suites Seattle in downtown Pioneer Square.
And then that's located at 255 South King Street?
Correct.
Okay. How long have you been the manager of the Embassy Suites?
June of 2018.
And was that when the hotel opened?
No, it opened on March 28th, 2018.
Okay. And were you at the hotel when it opened, or just you started in June?
I was not. I started June 1st.
Okay. And how many years of experience do you have in the hospitality industry?
18.
How much of that is in Seattle?
June of 2018.
And my understanding, for the record, is that you're here to testify today as the general manager of the hotel. You're not a representative of the Hilton enterprise or Hilton generally.
Correct. I am testifying as a manager-operator of the Embassy Suites and not as a representative of the ownership group or as the Hilton enterprise.
Do you have personal knowledge of the hotel operations?
I do.
What about its clientele?
I know the type of business traveler, corporate traveler, type of traveler that is coming to the hotel. I engage with them 6 days a week. I've done that since June of 2018. I'm responsible for working with the sales and marketing team to contract corporate, permanent business travelers, as well as the type of travelers that come for stadium events and cruise travelers, things like that.
Are you familiar with the proposed improvements to the Seattle waterfront?
I am.
Okay. And do you see these proposed improvements providing special benefits to the Embassy Suites?
I do not.
Why not?
This specific project would not change our model of occupancy. It wouldn't change our strategy with rates, and it wouldn't change the type of customer that we're already getting.
So what is your current model of occupancy?
Because this is recorded, I don't want to give too many specifics because of competitors and things of that nature. The predominant traveler to our hotel is coming for stadium events. It's coming from corporate or negotiated business that we've contracted, permanent business that we've contracted, and leisure cruise travelers.
Okay.
Is predominantly what makes up the mix of traveler.
Okay. And can you give me a very high-level breakdown of what percentage of guests come to your hotel for events that happen in your hotel?
Events that are happening in our hotel, whether it be weddings, meetings, things like that, would probably be around the 25%.
Do you have an estimate for corporate groups?
It's all encompassing because corporate, negotiated, international business traveler, it's probably around the 20 to 25% range.
Is proximity to the waterfront something that your hotel advertises?
No.
Do you advertise proximity to the stadium?
Yes.
What about proximity to Pioneer Square?
Yes.
Okay. How do you know, or why do you think that the proposed improvements aren't going to be a benefit for the hotel guests?
Of the 282 rooms in our hotel, only 24 have views of the actual waterfront. So we have 23 floors. We only consider the view rooms from the 12th floor and up, and there's only 2 rooms per floor that have a west-facing view that would even be able to see the waterfront.
And when you say see the waterfront, can they actually see what's on the waterfront, or do the buildings in front of you block that view?
There is, I mean, I would say between floors 12 and 16, it's very limited. You would see more water than the actual waterfront.
Okay. Okay. Now, you work in the area 6 days a week.
Yep.
Do you ever go down to the waterfront?
No.
Okay. Why not?
It's not a path that I would travel unless I was going to like the Science Center. I mean, even if I was going to Pikes Market, I would travel on First Avenue and walk up the mile that way. It wouldn't make sense to go to Alaska and then kind of come back. So that's issue number one. But we also have a shuttle that is in front of the hotel where if we needed to take a shuttle, it would take us there. It's a lot more convenient for our guests that stay in the hotel.
Got it. Do you think you're more likely to go to the waterfront after the changes are made with the LID improvements?
No more than currently.
Okay. That's all I got. I don't have any additional questions.
Okay.
Just some follow-up.
Yep.
You were just asked about the waterfront. How do you define the waterfront?
I would say from King Street in Alaska to the pier, port.
Which pier?
Port, I think it's 54.
Do you know if the Embassy Hotel has retained an appraisal expert related to this case?
I am not aware.
So you haven't spoken with any appraisers in connection with this case?
No.
Okay. No further questions.
Any redirect?
No, not at this time.
Thank you.
Thank you.
We have one more witness that's available Wednesday morning, but not available this afternoon. And we have Duana
Yes.
and SEPA issues that we'd like to address with Your Honor.
Okay, so you have one witness to appear on Wednesday for approximately how long on direct?
Probably a half hour.
Okay.
She's the manager of the Courtyard Marriott.
Okay. And you said something else, but I didn't catch the last
Duana
part.
Koloskova is.
I'm sorry, I can't hear you.
Duana Koloskova is an attorney representing the property owners on the SEPA issues, and her plan was to come Wednesday morning and address SEPA issues with Your Honor.
Or just present argument?
Mhm.
Okay. On SEPA. So just legal argument?
Yeah,
on that?
and we
Okay.
have a few exhibits to go with that.
Okay.
And then I thought maybe, I know it'd be good for me to spend a few minutes making sure I have straight the exhibit list with your exhibit list. And then we have a few items to offer, such as the objections themselves and a few.
So the objections we have already.
Okay,
they're
so we
part
don't
of
have to
the
worry
file.
about
Yeah,
those.
Right. yeah.
Okay.
Anything that was, the objections and anything submitted with them, sometimes, I don't know.
Okay.
I mean, I could look at it, you've got more than the objections here.
Okay, okay.
Because they're attachments that,
Okay.
whatever attachments were submitted with that, those are all part of the record already.
Okay.
For example, looks like there's a motion for pre-hearing conference, and some other items that are in here.
Okay, great. And then we just had then, I think it was just the one other topic around the relationship and the role the Friends of the Waterfront has played in requiring the LID. And we have four exhibits to offer on that topic.
So you have some exhibits, okay, that
And I
maybe
could do those
come
now.
through council, or, yeah, we can do anything
Yeah.
now, we've got time.
Yeah.
so.
Exhibit, or tab 44.
It's going to be 52.
That's Resolution 31768. And then we have the mayor's transmittal letter regarding the resolution of intent. Our tab 45.
Okay.
And then tab 46 is the resolution of intent.
It's 54.
And then our tab 52 is a transcript of the Friends of the Waterfront comments on May 18th, 2018.
That will be 55.
If you'd like me to, I could do the SEPA ones now, and then they'll be numbered, and we can refer to them by your number on Wednesday, if you want.
That'd be fine.
Okay. Our tab 47. The excerpt from the Elliott Bay Seawall Project.
I'm sorry, I can't hear you.
It's an excerpt from the Elliott Bay Seawall Project. Our tab 47, I believe now Exhibit 46, or 56, sorry.
All right, let's, before we do the SEPA,
Okay.
let me check. Were there any objections to 52, 53, 54, or 55?
I just have a question about 55. Is this a document that was prepared by council or
No,
printed from a website?
It was from the audio recording, and Mr. Williger's legal assistant typed it up.
Transcribed it?
Yeah.
Okay, thank you, no objection.
Okay. 52 to 55 are admitted. For the SEPA documents, I'm okay with marking them today, but I don't want to get into admissibility since they're being submitted in association with argument that another
Okay.
council is going to be addressing, and
Okay.
this
Can
isn't.
Hold it for,
Yeah, we can mark them, so we
Okay,
have
okay.
exhibit numbers, but again, I'm not certain we're going to allow heading down a track of substantive SEPA arguments
Right,
where,
right,
you know, there's
right.
going to be significant impacts. There's
No, no,
SEPA
it's
appeal
nothing
here, so
like that,
I
yeah,
can't
yeah.
tell what this is, and we'll have to wait and see. So for now, I'm going to hold off on admissibility. 56.
and then tab 48. Or, yeah, our tab 48 are the petitions for review. Seven.
That's 57.
Tab 49 is the SEPA settlement agreement.
That'll be 58.
And then I believe 50, Your Honor, was already, our tab 50 was already admitted.
All I can tell you is it's empty, so.
Do you know what number that was, Galen? Our tab 50? I don't know if you're trying. Oh, 38, maybe that was your exhibit 38?
38.
Yeah. Okay. And our tab 28 came in, right? I think that's it, Your Honor.
Okay. Thank you for getting that addressed. So that leaves us with the witness for Wednesday, half hour, and Duana. You had, at the beginning of the hearing, of this segment of the hearing for these objectors, you had asked about keeping the record open.
Mhm.
You've got a lot of time, so
Mhm.
what are we keeping the record open for? You're not out of time, so.
Right. I think the biggest challenge we're having, Your Honor, is that we haven't been able to depose the city's appraiser and cross-examine him.
So you will
and-
be able to, so that's, okay. So, I'm sorry,
Yeah.
I won't interrupt you. Let's just keep an eye, let's make a list of the things and we'll go through each one at a time. So
Okay.
there's this city witness with deposition and cross, and that I will hopefully be addressing, and I'll discuss that when we get to it.
Okay.
Okay.
And then the other one is also LID administrator or engineer that's responsible for the before and after conditions, the plans and specifications, the conditions that.
Is that the same thing?
Yeah.
That there's a deposition and maybe cross, or?
I think that's in dispute right now.
The deposition is in dispute, but the city has indicated they're going to call that person as a witness, I think.
Okay.
Okay.
So we'll be able to cross them at least.
Okay.
Okay. And then also we are trying to develop some testimony around cost estimates, which we anticipate will come through another objector that we're working with, but just want to be able to adopt by reference, that testimony, which it sounds like that's going to all be work out. That's okay. That's allowed.
Let's just get down the
Okay.
list. What else you
And
got?
then we have an architect making a small calculation on green space for the waterfront, and we're anticipating an expert engineer to talk about percent of design and where the city might really be in terms of its percent of design and thus its cost estimates.
Anything else?
I think that's it. That's the universe.
All right. So as far as city witnesses go, I have received a motion that from Mr. Lutz, who's asking to have oral argument on the opening for his cases, which is March 3rd. That's the only thing I've heard about depositions so far. I did issue a ruling essentially indicating that if the parties could accommodate depositions, please do so, but that the request for depositions had come in well after the date for the hearing. Date for hearing was set well in advance, so requests for discovery were coming in after the hearing had already started. If there's an opportunity to work things out and to make that happen, I've accommodated that. But if there's discussion about additional depositions, we'll have to deal with that on the 3rd. I can't rule on that now, but what I can tell you is that if, and I probably will be issuing, hopefully later this week, depending on how much time I'm in hearing, an order concerning scheduling, when the city's going to go, when the cross-examination is going to be. We have dates set for those, and also at that time address potential. I expected after individuals cross, they've already put on their case in chief that they're going to want to have some, at least, statement about that, some argument. And so I will likely leave the record open. I haven't determined a schedule for that, but if a witness is called, whether it's the city appraiser or this administrator, then barring some significant accident or legal standard that I'm not aware of, there would be the opportunity to put something in the record on those. So because that's logical, and you just haven't had a chance to do it. There's nothing, I'm not leaving the record open anything to come out of deposition, because that's purely there to inform cross-examination. So you don't need the record left open for that. I will address that. You'll have the same privilege as every other party does. And there'll be some restrictions and guidance on how to do cross-examination that'll probably be less directed at you as some of the pro se litigants we may see coming in. The cost estimates. Tell me more about that item.
Well, again, one of the really foundations of the appraisal and the project is what are you building and how much does it cost? And it really informs, to Anthony Gibbons' testimony today, how you value the improvements themselves and how you value their impact to their surroundings. And the cost estimates are driven by percent of design, which remains.
Let me clarify my question,
okay.
and I'll ask it for the remaining 3 items. There's cost estimates, an architect calculation of green space, and an engineer commenting on percentage time. Why aren't we ready to go with those now for the objection with the time you were allocated?
We haven't been able to secure them. We've been
I
dealing
get
with
land
hundreds of
use pro
cases.
se litigants in front of me that had 2 weeks to file an appeal, and they're in front of a hearing, and they don't get that same argument. It doesn't work for them, right? They're in hearing, so.
Well, but we've been trying to coordinate with the other appellants, right? So it's
Right,
not that
so-
I'm bringing in
Sorry.
necessarily someone new for just this. I'm just trying to make sure that I am able to continue to take advantage
So
of the other evidence
what I will
presented.
do is allow you to, can you identify who you're doing this with?
With the Perkins Coie?
So is this Representative Mr. Lutz?
Yes.
Okay, so if you want to now incorporate his argument, then you've put your finger on that, and
Okay.
then he can notify us all when that's coming in at that time.
Okay.
Okay. So that's allowed.
Okay.
All right. Under that format. But I'm
Gotcha.
not expecting something independent to be coming
Right,
from
right,
you,
right.
but
That
it'll be
wasn't-
coming during Mr. Lutz's time.
Correct.
Okay. Are there any of these items that you were just wanting the record open for, except that's not in that format?
No, I don't think so.
Okay.
I think even our architect's calculation will be very small, and we can bring it in through multiple parties.
Okay.
Yeah, with
All
Mr.
right.
Lutz. Yeah.
The two other cost estimates and the architect calculation don't raise a lot of concern. Certainly, you can do those through the time when Mr. Lutz is presenting. The expert engineer, is his testimony, or anticipating that there would be additional testimony from a witness that he's calling, that it would also be speaking to your case?
It won't be to the individual properties or the individual owners. It's more to the baseline.
And I mean the engineer. Is this
Right.
You said there's an expert engineer. Is this
Right.
testimony, or is this
W-
what's the
w-
format?
I imagine it might be testimony. It depends right now, because we only learned like literally 5 days ago, trying to put this all together, where the shifting sands are going with the plans and specifications. And so we're just trying to make sure that we do understand where the city is at on their designs, and we do know what it's going to cost, so that the baseline condition and the improvements themselves are properly understood.
Okay, so what's already been communicated to every party, including you and Mr. Lutz, and I did this on the 4th, is that every party's getting the amount of time, essentially, that they asked for.
Yeah.
And obviously it shifts with schedules, and it didn't work out for everybody, but everyone's at least gotten what they asked for, including Mr. Lutz. And just as you're working it out with him, just this has to work within the time he's gotten.
Yeah.
So
Yeah.
that's going to be
Yeah.
up to him.
Yeah.
But I will leave the record open for this case to essentially reference back during that period for the engineering testimony, the architecture calculations, and the cost estimates you referenced, but no other items. So, because that's what's identified today.
And can I ask one question? Will we all be able to submit like a closing brief like we
I
traditionally
knew there
do?
was one thing we were missing. No.
No closing
yeah,
briefs.
You can do, what my intention is that after you've done cross-examination, obviously, there's nothing in the reg. I mean, if we just closed, then there'd be cross-examination, and you wouldn't have an opportunity to argue with anything. So I
Right.
am anticipating limited argument in written form to be allowed following the cross-examination by parties who did participate in the cross-examination, not just
Okay.
everybody under the sun.
Okay.
For those parties that want to do closing as part of their objection, they should be doing it during their time. So you can either submit it
Okay.
in writing, or you can do oral argument, however you want to do that.
Okay.
If you want to give a closing argument, you had a pretty lengthy intro,
Opening,
and
yeah.
I think Mr. Gibbons's testimony was clear and concise. So other than that, I don't think you have a lot to marshal for me in
Okay.
a brief anyway. But if you want to do a closing, you certainly are welcome to do that and use your time set aside on Wednesday.
Okay. All
Okay.
right.
Any other questions? Okay, great.
Not
Anything
from
from
me.
the
Oh,
city?
yes, actually, I do have a
Yes.
question.
Uh-huh.
Would it be helpful for us to submit replacement copies for exhibits 1, 2, and 3 that have the actual exhibit numbers in them rather than our?
Page numbers, correct?
Yeah, would that be okay?
Oh, that for sure.
The page numbers as well?
But also, since we changed the exhibit numbers, we could change the citations for you as well.
Oh, yes, you could do that.
Okay.
Sure, that's
Okay,
fine.
we'll bring that on
Any problem
Wednesday.
with that from the city?
I don't think so.
Okay,
Thank you.
Great. Are there any procedural items we need to address before we adjourn?
None
Okay.
for us.
The Waterfront LID hearing is adjourned for today. We'll reconvene tomorrow at 9 a.m.